inspection, my lord. And my lord, one matter, a company matter, its affidavits are complete, my lord. Let it appear on next Wednesday, my lord. I'm grateful.
May I have your lordship's kindly? This is that matter which was mentioned by Mr. Dotto yesterday in the afternoon. Now, my lord, the learned master is saying that because the words presented and admitted are not there in paragraph 3.
But you are not paid for any leave.
No, but
it is the master to
no, that I've checked up the original side rules. It can be presented in court, but can also be presented before the master.
Correct.
And I had taken leave from your lordship on Tuesday. The matter was placed for presentation of plaint. I also checked up the live stream. I did present the plaint. And so, the plaint. Anyways, your lordship has admitted the plaint. So, those words, unless that is done, she is saying she'll have to list it and the plaint has to be presented. Then the order goes. So, in the third paragraph, just the words from this court, the word court is also missing. And that the plaint was presented and admitted has to either appear from the fiat or from this order. So the scrutiny is not proceeding otherwise.
Okay, I will talk to the master. I will talk to him.
My lord, may I have my lord's kind leave to mention item number 79 of my lord's list. It's a suit, my lord. I have taken out an application for appointment of a commission. Now, the difficulty is my witness, the plaintiff, is not keeping well. If the application can be taken up anytime, my lord, it
What for what?
Application for appointment of a commissioner, my lord, for taking the evidence of the plaintiff. So I was humbly beseeching my lord keeps the application any day convenient to my lord because my client is not 79.
No, it will not be taken.
May I permit to mention?
Not be taken. How it can be?
Not today. Anytime next week, if my lord kindly pick.
That cannot be. Let it be in the list. When the matter call, you mention, or the juniors can come and take adjournment. From the list, this court will not adjourn any matter.
I am not asking for any adjournment.
Sorry, sir.
I am asking for fixing of date, my lord.
I will not fix any date. This is a total no commercial matter. Whenever the matter will be taken, it will be taken off a hearing.
May I permit to mention the probate matter, madam? Lordship was pleased to pass the order for granting probate on 14 January 2015. Today we are April. One of the department is used to draw up.
I am not having determination now.
Only
this court is not having determination to pass any order in the probate matter, sir. Yes.
Lord, may I be permitted to mention, my lord, a suit, my lord, where your lordship by an order dated 24th of March 2025, my lord has rejected the defendant's application to file the written statement. My lord, consequently, the chance to file the written statement is disallowed, my lord. I was only praying, my lord, if your lordship passes a direction on the department, my lord, to only take the written statement off the record.
Written statement?
Off the record, my lord, because your lordship has rejected the application filed by the defendant. My lord,
it is not accepted. Not accepted.
Because, my lord, there was an order, there was an earlier order passed in this application that the written statement shall be taken on record subject to the outcome of the application.
Outcome it is.
Right.
So it is
Right.
not there.
Lordship, may I have you leave to mention a matter for drawing up and completing an order dated 20th of March 2025?
Lordship, may I be permitted to mention the mention for leave for extension of order dated 4 January 2023, 17th May 2023, and 17th October 2023.
What?
Lordship,
Yeah, see. Draw up and complete.
Lordship, on 4th January 2023, GA1 was rejected, dismissed for default, and 17th May 2023, GA2 was rejected, and GA3 on 17th October 2023, it was also rejected. Now I'm praying for Lordship for appeal for drawing up of all orders, Lordship.
After 2 years, you're coming, 1.5 years, you're coming for drawing and complete the order.
Lordship, erstwhile advocate has not taken any steps, and this is a matter of Union of India. Now new appointment has been made, and Lordship, they preferred an appeal.
So?
Lordship, if leave could be granted, Lordship.
For what?
For drawing up of all orders, Lordship.
Yes. Yes, you will get.
Item, may I mention one matter? My lord, on 24th March, my lord had granted me leave for the purpose of carrying out correction in respect of the defects indicated in CS in a suit, my lord.
my lord, the period of 7 days was granted. My lord, the period expired by the time the file could reach. My lord, I'm only praying if the matter can be listed as to be mentioned or can be taken up in any date convenient for extension of the time to complete the
Why
scrutiny, my
you
lord.
persons are not maintaining the time which the court
My lord,
fixed?
my lord, I had charged up on that, my lord. The problem was there were 3 days holiday in the middle, which is why during this period the time expired, my lord, and it took some time for the matter to.
Give the number. Yes.
My lords, may I mention item 15, which is in today's list, my lord?
Yes.
My lords, this was listed for arguments, Mr. Ghosh, but when we informed Mr. Ghosh is supposed to continue his argument today, my lords. My lords, I may be permitted not to appear today, my lords. I'll appear on the next Friday, my lords.
I think Mr. Ghosh has completed the argument.
We requested our local AOR connected with them, but
Okay, when the matter call, either you or any junior mention, I will sit.
please, oblige.
Yes, call the list.
Milord, item number 1, Milord, is fixed for Milord filing notes. Milord, my notes
My
are
learned
ready,
friend
final
is-
notes.
Milord, notes are ready, Milord. I have not come here to file my notes. I was looking for my learned friend. Milord, my learned friend had given his judgments. I have given his judgments. Only thing is, Milord, I have come across a judgment of 2025 January of our appeal court, which Milord has considered the previous judgments and has laid down somewhat as to what contemplation means, because he was arguing. But I have not annexed it to my notes because I have not cited it when I was arguing. I was looking for my learned friend. If he
Milord,
wants,
Milord, like this, Milord, the relay will go on.
No, what judgment? No, it is a judgment. Then let the court.
if you
Then,
want, you
Milord,
can
then I
deal
will
with
have
in
to.
your notes.
No,
You can
I
deal
don't
with-
want. I don't want. Milord, I
what is
want
the
the
judgment?
closure. I don't want.
What
Milord,
is
I
it?
want the closure.
Okay, then I will record you. You will not want to deal with this judgment. No problem, sir.
He has done his, Milord. Milord. Only thing is
Mr.
that
Dasgupta, Mr. Dasgupta, even the court, if they found that new judgment has come, that has to be considered. Why the court can overlook the latest judgment? He is not arguing the matter on merit. He only,
it's my
Mr.
lord.
Datta is
This
submitting that and latest judgment he wanted to deal.
He can deal with it
So
if
let
he wants.
this court may get an opportunity to go through the latest judgment of the division bench of this court, so that both the party and the court can also be.
Milord, page 5, paragraph 8, Milord. This is something, Milord, which is also followed in Gabriel and this bench. Milord has said that contemplate would mean a paragraph 8.
Yes.
So 12A of the Act requires the court to ascertain whether the suit contemplates any urgent relief arising out of commercial dispute as defined as. Contempt means a deliberate consider whether regard being had to the facts and played any urgent relief is called for. It would imply that in die cast and bolt impending that the act is done in expectation of with a view to it, or that the dispute is already existing and the act is done in support to one side of it. Judge is required to consider and apply his mind to the facts of decision, keeping in mind urgent intent and relief would mean that the matter cannot wait for initial period of 3 months as required under 12A3 of the Act. Look, the 3 months which is taken for mediation, the plaintiff cannot wait. This is something, Millard, which I did not argue, but I found that the interpretation is there by the division bench following 2 previous division benches. And mine is an application which is effectively within a month.
Well, Milord, may I give 1 minute reply?
Yes,
Not
please.
even 30 seconds.
Yes.
Milord, first of all, this 1 month that the cloud is tried to be, Milord, given from the first day, Milord, is more than 2.5 months. Milord, he should be correct with the dates. It was, Milord, admitted on 6th of September. We have filed, Milord, our application on 11th of November. They have served on us their injunction applications contemplating, Milord, urgent relief on 22nd of November. Milord, 1 month, how does 1 month comes, Milord, I fail to understand, number one. My calculation may be wrong on this. Now, Milord, paragraph 8 of the judgment. Milord, it's the same thing which, Milord, just Aidunkaji said. Contemplation is, Milord, mindless discretion to look into. My Lord, I have shown paragraph 20, page 17. My Lord, I have shown, may I? My Lord, I have shown, Milord, paragraph page 20, paragraph 20, page 17 of my application. My lord, the same relief has been copy pasted 2.5 months down the line in November 2021. My lord, that is paragraph 20 of my lord, the GA3. So, my lord, the one liner is contempt. If that is contemplation, then my lord, no suit will go for any mediation. Let me, it is better to remove 12A. Number one. Number two, Millard, if Millard sees Yamini Manohar paragraph 10, Millard, it is very clear that in disguise of a pleading, Millard 12A cannot be given a go by. These are my submissions. These are the same line, Millard, nothing new. And Millard, the same judge, Millard, the same bench, Millard has passed the contra judgment in December that I have relied.
That is the reason why I cited it, because I was also trying to find out how could the same bench.
So, it's upon your lordship.
It will be decided by the
court. It's on the facts. It's on the facts. Millard, the law is well settled. No judgment, Millard, is beyond the facts.
Of course.
There cannot be. Millard, those are my submissions. Millard can take it that I've dealt with the judgment.
Okay, thank you.
Thank you very much.
Okay.
So appearing for the plaintiff, so appearing for the defendant. Both the parties have filed their written notes of argument. Let us make up with the record. Learned counsel for the plaintiff has further relied upon a recent judgment passed by the Honorable Division Bench of this court in FM 83 of 2025, dated 17 January 2025. And the learned counsel for the defendant has also given reply to the said judgment. Let us make up with the record, CAV.
Deeply objection.
Number 2. For that item 2, my lord, I appear for the plaintiff.
Yes.
There are some defects, my lord.
Huh?
There are some defects, my lord.
Defects?
Yes, my lord.
How many defects?
My lord, in the affidavit of competency, list of documents in the plaint also, my lord.
Verification of the statement of truth is not in form. Affidavit under 11 is not in format. Signature of the party is not proper format. There is a format of the signature of the party.
My lord, in yes, in one affidavit, my lord, we write that by the pen of, it should not be written over there. Instead of that, only the name should be written. All this, there are some spelling mistakes and all this.
So appearing for the plaintiff. The matter is placed before this court on receipt of the report from the Office of the London Master. It is found from the record that at the time of scrutiny, the department has found altogether 6 defects. Counsel for the plaintiff prays for how much time? 2 weeks?
My lord, 2 weeks. 2 weeks, my lord.
It will be over.
My lord, the
3 weeks time
that, my lord,
to cure the defects.
My lord, the person will be
And
coming from
also
Odisha.
prays for you to re-verify and reaffirm the affidavit of the plaintiff. Accordingly, plaintiff is granted liberty to cure the defects within 3 weeks and also to reaffirm and re-verify the affidavit of the plaintiff within a week thereafter.
I'm grateful, my lord.
Next.
Number 3.
But I'm instructed there were some typographical mistakes in 4 places in the plaint, because of which some corrections were made. If your lordship takes page 1, your lordship will find the typewritten.
Yes.
4 pages, page 1, page 2, page
Of the
14.
plaint?
Yes, my lord.
Page
And
1.
page 1. Your lordship will find there were these typographical mistakes. The original side has been printed. I think it's been typewritten.
Yes.
Then within jurisdiction, outside jurisdiction, they were typewritten. Similarly, page 2, within jurisdiction was typewritten. My lord, if your lordship then takes page 14, my lord, the figure was wrongly mentioned. The figure is as per para 17. There is no mistake, my lord. It is, I think there was a typographical correction which has been made by typing it out. And finally, my lord, page 20, again, my lord, all the annexures have been typewritten. This is the problem, my lord. That is why, my lord, my learned friend has brought me to, my lord, if this...
So this typing has been done after the affidavit or
After
before
it.
the affidavit?
After the affidavit.
How it can be?
My lord, I am instructed, my lord, that that's what he's telling me, my lord. The small typographical mistakes, those can be changed. There's no material altercation at all. Only, my lord, this within, outside, and format is also correct. And if your lordship sees, my lord, the prayer.
That's why I find in this court only after the affirmation the document is giving to the parties. It can't. Even I find the affidavit in opposition, plaint, written statement, affirmation giving to the parties. Once affirmation is done, it is the record of the court.
I think, my lord, after it was filed, then these typographical mistakes were noticed. My lord, if your filing was accepted, if your lordship, my lord, sees para 17, no mistake. Yes, my lord. We'll be more careful, my lord.
So appearing for the plaintiff. The matter is listed as to be mentioned on receipt of the report from the office of the master of this court. It is counsel for the plaintiff submitted in page number 1, 2, 14,
20 and 21.
14, 20 and 21. 21.
And, my lord, similarly, the writ of summons also where the same changes have been.
And in the writ of summons. And in the writ of summons, the plaintiff by mistake after the affirmation of the affidavit of the plaint has typed in the set has made some correction by typewriter, and as such the counsel for the plaintiff prays for apology that the same correction has been made without the leave of the court and after the affirmation of the affidavit. Consider the submission made by the counsel for the plaintiff, the correction made by the plaintiff in the plaint at page number 1, and 1, 2, 4, 20 and 21. 21 is accepted. Correction made in itna by true typewriting. True typewriter is accepted.
My lord,
as well as in the writ of summons.
My lord, my mistakes. Para 9A also, my lord, at page 7. I'm sorry, my lord, I didn't notice it earlier. Your page 7, 9A has been also typed in paragraph 9A, page 7. That is my mistake. I didn't notice it. Page 7, 9A has been typed in, my lord.
And in page 7.
I'm sorry, my lord, I should have seen it. I'm obliged, my lord.
Presentation of item number 4.
This is my plaint.
Yes.
The claim is arising out of goods sold, delivered, and part payments made.
Yes.
The last payment was made on.
What you afraid to? That's yesterday it was moved, na? Why order?
That was different.
Why order to rule 2 again?
There's same pair that I am not pressing.
You're not pressing this.
Not pressing that leave.
That's why you're not pressing this order to rule 2 leave. That's all.
Well, your lordship may grant one thing. Not pressing at this stage. Well, this is unseen requirement.
So and so appearing for the plaintiff. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 30,63,024 along with interest at the rate of 18%. Full stop. In the prayer portion and in the concise statement of the plaint, the plaintiff has prayed for leave under order to rule 2 of the Code of Civil Procedure 1908. but when the matter was moved, the learned counsel for the plaintiff not pressed the leave as prayed for under order 2 rule 2 of the Code of Civil Procedure 1908. Accordingly, leave is granted to the plaintiff to not press the leave under order 2 rule 2 of the CPC at this stage, my lord. Get to the plaintiff be placed before the learned master for appropriate order.
Item number 5. May I have your lordship's kind leave to present this plaint?
Yes.
Your lordship, this is my plaint seeking the specific performance of a
Why it has
particular
come to the
agreement.
court? You have not asked for any leave.
Your lordship, we had already referred the matter for mediation and the non-starter report has been annexed here.
That's I am sending you to the master. Master will admit this.
Wait for you.
Though the matter is fixed today, listed today under the heading presentation of the plaint, but after going through the plaint, it is found that the plaintiff has not prayed for any leave from this court. Accordingly,
Your lordship, your lordship, we had referred the matter to mediation. The non-starter report is annexed.
non-starter is reported that you mentioned.
Okay. Very well.
You have not prayed for any leave. That's why this court cannot give. Kya bola? Now, after going to the record, this court find that the plaintiff has also initiated pre-mediation process and non-starter report is issued on 21st of January 2025. But the plaintiff has not prayed for any leave from this court. Accordingly, the plaint is sent to the master for appropriate order.
Wait for you.
Item number 6.
Lord, I appear for the plaintiffs. Lord.
Yes.
This is that application for demurrer which I had taken out, Order 7 Rule 11, in the view that they have filed a suit in the commercial division. I have said Deepak Polymer was holding the field. How could you have filed a suit in commercial division? To which they have filed an affidavit, though belatedly. But may I file a reply?
Lord, may I
Since
file
they have
my affidavit?
not required, but since some facts have been stated,
What has happened? No, not decided.
Lord, the matter, my lord, the last order I'm carrying, my lord, perhaps notes of arguments have been exchanged.
Yes. And in any event, my point is within that period, Deepak Polymer was holding. Even if it is upturned, that was the law at that point.
Sense and suffering for the plaintiff, sense and suffering for the defendant. Plaintiff has filed the affidavit in opposition. Plaintiff has filed the affidavit in opposition in connection with GA5.
GA5.
GA5 of 2025. Let the same be kept with the record. Counsel for the defendant, please for time to you time to file reply.
Reply.
Please for time to file reply. Let affidavit reply be filed within 2 weeks. 2 weeks. Within 2 weeks. This is the matter. On 22nd. Under the same heading. Under the heading new adjourn motions.
Lord, only one thing, my lord, could it be on a 23rd, my lord, instead of 22nd?
Okay, 23rd kar dein. 23rd. Yes, next.
Number 7. I appear for the defendant.
Yes, ma'am, my application, my lord. There is already a subsisting interim order that has been extended time to time. Now, my lord, it is appearing after exchange of affidavits.
Yes.
Well, before I take your lordship, my lord, through the documents, my lord, one statement that has been made by the bank in the affidavit, lordship sees, my lord, because this was their only defense, my lord, to my prayer for an order of injunction, that they were never aware, they were not aware, and I did not inform them at all that I am a registered MSME unit. If I have not informed them, then, my lord, I cannot take the benefit of
the effect.
Yes, then I cannot take the benefit of the framework of 2016. My lord, they have indicated that stand. My lord, if lordship takes their affidavit in opposition, the first volume, My lordship takes page 15. This is paragraph 3, subparagraph 16. Sorry, paragraph 5, subparagraph 16, page 15.
Yes.
Yes, my lord. Kindly see, my lord, 7 to 8 lines from the top, sentence which starts from the middle of the paragraph. Also, at no point of time was it brought to the knowledge of the respondent bank that the petition number 1 was a MSME, or that there was no purported non-compliance of any mandatory guidelines or to the classification of the loan accounts as NPA. The petitioners have for the first time raised such disputes in the instant suit which they are stopped in the instant which they are stopped from raising at this stage, where the respondent bank has considerably proceeded with the SARFACI action as well as the application filed under section 19 of the RDB Act 1993 before the Debts Recovery Tribunal. Now, my lord, I have already filed my affidavit in reply, but my lord, one document we have recently traced, my lord, it's of 2022. My lord, kindly see this bunch of emails, but I also give a copy to my learned friend. Oh, আমি দিয়ে দিচ্ছি।
Let it not be taken by surprise in an
No, no, it's-
argument day. This
No,
should
it's
be-
You will get the opportunity.
yes, because my lord, this is the bank's letter. It is the bank's document. একটা copy দাও না।
Answer. नॉन कमर्शियल है उनको बुला के बोल yes
Yes, my lord, kindly see, my lord, the bank, this is an email that was received by my client. My lord, the email is dated 4th of February 2022.
yes
My lord, kindly takes the attachment which was sent to us, my lord. My lord, during COVID, my lord, if this was an approved loan facility for guaranteed emergency credit line. My lord, the document which was attached to the email. But this document is dated 4th of February 2022.
yes
And my lord, lordship will kindly see, my lord, this document also has an annexure A
yes
towards the bottom. Now, my lord, kindly see, my lord, annexure A, which is the last document or the second last document of the bunch of documents that I have handed over. This is the annexure A that I had to fill up and I had to make over to the Chief General Manager of SBI SME Park Street branch. Kindly see, my lord, 2A
yes
of annexure A.
yes
We are functioning business enterprise / MSME with Udyog Aadhaar number such and such, if available. I had to fill up this form and I had to send it to the bank. Now, my lord, my response is, my lord, 7th of February 2022.
so you do one thing
Yes.
you come with a supplementary
Very well.
affidavit,
That
give the
is what-
copy
Very
to
well.
them so that they can also
Very well.
deal with
I'll
from
do
their
that.
document.
Yes.
Because this I have to take
Correct.
instruction.
Now this is a documentary, so come
Yes.
with a supplementary
Yes, well,
affidavit.
I'll do
You
the
give
needful.
the copy to her.
Grateful.
Lordship will kindly make it a little time bound because it will be only on one document because we are already suffering the audit.
So and suffering for the plaintiff, so and suffering for the defendant. Though the matter is fixed today for hearing of the injunction application, but the counsel for the plaintiff submit that after filing of affidavit in reply in connection with GA Com 1 of 2024, the plaintiff has got the documents of the year 2022, which is relevant in the present case. According, plaintiff intend to bring the said documents on record.
Lordship will record my objection.
Record, full stop.
At the
Counsel
date.
for the defendant bank raised objection and submitted that the plaintiff has neither disclosed the said document in the plaint nor in the affidavit in reply, nor at the time of hearing of the injunction application, the same cannot be allowed. Heard the learned counsel for the respective parties, this court find that the plaintiff is relying upon the document issued by the bank, and in reply to the said document, the plaintiff has sent the reply. Accordingly, the plaintiff may be given an opportunity. According this court is of the view, one opportunity should be given to the plaintiff to disclose the said document by way of supplementary affidavit. so that the bank can also get an opportunity to deal with the said document. In view of the above, comma, the plaintiff is directed to file supplementary affidavit by disclosing the said document within a week from date after supplying the copy to the learned counsel for the defendant. Full stop. The defendant is at liberty to deal with the said document by way of affidavit in opposition to the supplementary affidavit within a week thereafter. And after supply the copy to the learned counsel for the plaintiff. The plaintiff is also liberty to file affidavit in reply, if any, within a week thereafter. This is the matter on 30th April 2025.
Lordship, 30th, I am not in Kolkata.
Second May.
Lordship, I will be returning on the 3rd. So Lordship will kindly keep it on the next week, except for 5th.
7th May. 7th May 2020.
Want the interim order to continue till
when is going to expire?
8th of April.
Counsel for the plaintiff submits that interim order granted earlier is going to be expired on 8th of April 2025 and prayed for extension of interim. In view of the submission made by the counsel for the plaintiff, interim order granted earlier is extended till 7th of May 2025 or until further order which varies earlier. Is the matter on 7th May under the same heading.
Yep.
My lord, appear for the plaintiff in the matter.
Yes.
This is a GA4 filed by the defendant for condonation of delay. They had not appeared on 4th last date also. On 2nd.
Then appeal defendant filed an application GA.com praying for extension of time to file return statement. Then appears on behalf of the defendant for the interest. Yes.
My lord, we are for the plaintiff, my lord. There is no defendant has not appeared on the last date also, my lord. This is their application for condonation of delay.
How many days delay?
Sorry, not condonation of delay, my lord. It is their application for
extension of time to file
to file return statement by 17. My apologies, my lord.
So appearing for the plaintiff, then appears on behalf of the defendant. The defendant has filed an application being GA.com 3 of 2025, praying for extension of time to file return statement. The matter was listed on 2nd April 2025. On the said date, also none appears on behalf of the defendant, and for the interest of justice, the case was adjourned till today. Today also, when the matter is taken up for hearing, none appears on behalf of the defendant. No accommodation is sought for. Accordingly, GA.com 3 of 2025 dismissed for default.
Number 9. Lord, I am for the respondent in this matter. They had filed the plaintiff had the defendants had filed a application under section 8. Defendant number 1, saying that there's an arbitration clause in the several work orders. My lord, affidavit in opposition was directed to be filed by 21st. We have served them on 29. Some delays there. But
I am for the defendant number 1, my lord. My lords, I'm praying for an extension of time for me to file the affidavit of
naturally, I cannot object to that.
My lord, may kindly grant me time till next Friday, my lord.
You are for the defendant number 1?
Yes,
Defendant
ma'am.
number 1.
Who is for the 2?
I am for the defendant number 2.
It's defendant number 1's application.
Yes,
So,
but I am also opposing
Opposing for?
the section 8 application.
You are opposing?
Yes.
So you're supporting the plaintiff?
Yes, because if Lordship sees the prayer.
Since opening for the plaintiff. Since opening for the defendant number 1 and since opening for the defendant number 2. Plaintiff has filed affidavit in opposition in connection with GA.com 4 of 2024 after serving the copy to the learned counsel for the defendants. So counsel for the defendant. You also file. You will also know.
I am also out of time.
Counsel, you want to file now?
I'll file my affidavit. It's only on a question of law because I have nothing to discuss.
Counsel for the defendant number 2.
Yes.
Prays for extension of time to file affidavit in opposition. Counsel for the defendant number 1 prays for time to file affidavit in reply to the affidavit in opposition filed by the plaintiff.
My lord.
Full stop. Considering the submission made by the counsel for the parties, the defendant number 2 is directed to file his affidavit in opposition within a week from by Today we are on 2nd, 3rd, 4th. By 11th?
Yes.
By 11th April 2024, after serving the copy to the learned counsel for the plaintiff as well as for the defendant number 1, the defendant number 1 is at liberty to file affidavit in reply of both the affidavit in opposition within 1 week or 2 weeks.
My lord may grant me 2 weeks.
Within 2 weeks, within 25th of April 2025, release the matter on 29th of April 2025.
I'm obliged.
My lord, I beg to appear on behalf of the plaintiff. Lord, this is my application for amendment of the plaint, and my lord, I have prayed for leave to disclose one additional document.
Amendment of the plaint.
Yes, your lordship, when we had moved,
or additional document. What is your prayer?
my lord, both.
Both.
Yes.
Which for the other side?
My lord, they had appeared. Your lordship had also passed directions for filing of affidavits. We have not received an affidavit as on date, my lord.
Nole Banerjee. Nobody's here.
No, your lordship.
You have not received the affidavit?
No, your lordship. We have not received any affidavit.
So, so appearing for the plaintiff, none appears on behalf of the defendant. By an order dated 11th March 2025, this court granted time to file affidavit in opposition in connection with GA Com 3 of 2025 to the defendant. Counsel for the plaintiff submitted. He has not received any copy of the affidavit in opposition from the defendant. Today, none appears on behalf of the defendant. No accommodation is sought for. For the interest of justice, the case is adjourned. Let the matter appear on 10th of April 2025. It is made clear that on the date fixed, if the defendant will not appear, the application filed by the plaintiff will be taken up for hearing in the absence of the defendant.
Deeply obliged.
Item number 11. In this matter, my lord, I am for the plaintiff respondent, my lord. Well, I am praying for not today.
Why?
Well, Mr. Sankarsan Sarkar is leading in this matter.
My amendment application on behalf of the defendant, where I have incorporated account
Amendment of written statement.
within the period of limitation.
Only not today.
Not today.
Monday I will do. Item number 12.
But I appear for the defendant number 1. But I appear for the plaintiff. Now, today was fixed the framing of issues. We brought a suggested issues.
Framing of issues?
Yes. But here, the plaintiff.
Not today, framing of issues.
We've also prepared an affidavit as to documents. May I file that?
What is the suit for? Recovery of money?
Yes, recovery of money. Defendant number 2 has not been appearing. It granted me time on the last occasion to get the service report. That still hasn't been appearing. I'll obtain that in the meantime. They've not filed the written statement.
Did have someone served?
Yes, my lord, but that report is not with me right now. But my lord can frame the issues for today, my lord, since they haven't filed any written statement. That is for a fact, my lord. And, my lord, may I file my affidavit of documents, my lord?
Discovery inspection completed, documents filed.
My lord, affidavit of documents we've prepared. Discovery is still not completed. My lord, will grant us. Inspection has not been offered to us. No.
How the
my lord, issues can be framed in the meantime. My lord,
we'll relying on one document. Hence, my lord, I have not disclosed any document.
The guarantee letter, my lord, had
relying on one document.
Passed a judgment in this matter in the interlocutory stage, my lord.
My lord, they were claiming for judgment upon admission on the basis of the comfort letter. Our submission was that the invocation was not in terms of the guarantee.
That matter.
Yes.
But Himachal Pradesh.
Yes. Thereafter, my lord, has put the main suit. This is the main suit coming up, my lord. My lord, discovery inspection will grant us 2 weeks time, my lord, we'll complete it. Suggested issues, my lord, we file if my lord deems fit, my lord.
Complete, my lord. So appearing for the plaintiff. Defendant number?
I am for the defendant number 1. My written statement has already been filed.
PGCL?
Yes, Power Grid Corporation of India.
Since appearing for the plaintiff, since appearing for the defendant number 1. though both the parties, none appears on behalf of the defendant number 2. Both the parties have filed their suggested issues. Let the same be kept with the record. It is found from the record the discovery and inspection of the documents have not been completed. Accordingly, parties are directed to complete the discovery and inspection of the document within 2 weeks. Within 2 weeks, full stop. Affidavit of admission and denial of the document will be filed within a week thereafter. Full stop. This is the matter. 2 weeks, 1 week, 3 weeks. Na? This is the matter on 28th of April 2025 for framing of issue.
But we've also filed the affidavit of document.
Affidavit of document filed by the plaintiff.
Agreed.
Affidavit of document.
In item number 13, I am appearing for plaintiff, my lord. In this matter, the inspection and discovery is completed by the parties, my lord. Only admission denial is left, my lord. So praying for a week time.
My lord, I have, my lord, already, my lord, circulated my admission denial, my lord. I am also carrying my suggested issues. My lord, kindly takes the last order of 21st January. My lord, directions were, my lord, given, my lord, to, my lord, complete the
discovery and inspection. Not completed.
I have done, my lord.
Not completed, my lord. We have also completed.
My
my lord.
affidavit
The only
of admission denial is
left,
also
my lord.
ready.
Only admission denial is left, my lord.
So far as the
Will be
plaintiff
done.
is concerned, so as defendant is concerned, well, I'm carrying my suggested issues. I have also, my lord, carried, my lord, the admission of affidavit of admission and denial. It's ready, my lord. So, my lord, can, my lord,
One time.
My lord, a week time, my lord.
How much?
1 week, my lord.
One
by
week.
next.
So you are filing today?
Yes, I can file, my lord. Kindly, my lord, takes on record my suggested issues by the defendant and the affidavit of admission and denial documents.
So and so appearing for the plaintiff.
Also, my lord, the judge's brief of document will on behalf of the defendant.
So and so appearing for the plaintiff. So and so appearing for the
My lord,
defendant.
my lord, a copy has been not served, my lord.
I'll serve.
Counsel for the
Copy.
defendant has filed affidavit of admission and denial of the document, comma, judge's brief of document and suggested issues. Have you served?
I'm serving.
After serving the copy to the learned counsel for the plaintiff. Let the same be kept with the record. Counsel for the plaintiff prays for a week time to file affidavit of admission and denial of the document, comma, judge's brief of document and suggested issues. In view of the submission made by the counsel for the plaintiff, time to file affidavit of admission and denial of the document, comma, judge's brief document and suggested issues by the plaintiff is extended for a period of 1 week from date.
Suggested issues.
This is the matter. This is the matter on 22nd April 2025 for
But I have served, my lord. I have served.
framing of issues. Huh?
Deeply obliged.
Next.
My lord, I appear to be addicted. My lord, I appear on behalf of the plaintiff.
Yes.
Now, my lord, in this
Appearing for the petitioner, my lord, we have filed an application on behalf of ABC Tea Workers Welfare Services for correction of the name of the defendant number 2. Alternatively, my lord kindly added me as a party to this suit because I am in possession of a room at the premises number 19 Netaji Subhash Road. I am ready to hand over because we have shifted our office.
my lord, my lord, I am for the plaintiff. There is an interim order which was passed by Justice Moushumi Bhattacharya during pandemic on 7th October 2021, which is against the defendant number 2, basically. My lord, defendant number 2 had purchased a portion of the premises, a conditional conveyance. And my lord, thereafter, defendant number 2, my lord, we are challenging that. And we said that you will not dispose of and alienate because it was conditional upon payment of a particular sum of money. Negative covenant is there. I have a charge over the property. Under, my lord, section 55(4)(b). This has been so recorded. Now, my lord, the injunction was passed on 7th October 2021 till, just a minute, just till, my lord, my lord, basically, my lord, under this, but your lordship, when your lordship took up the matter, I said This is an old matter. Is pending for such a long time. Interim order is subsisting. So confirm this order and expedite the suit. To that, your lordship, they said, "Oh, I want to file opposition." So your lordship gave them the luxury of filing the opposition, which none has filed till date, in spite of 2 extensions granted. So, my prayer would be, first to confirm this portion of the order, restraining them from disposing or selling, and the defendant number 3 and 4 are the people, who have purchased that portion, small portion from them. On that day, the first day, so I said they have not filed written statement, they have done nothing. I said on the previous occasion that they should also be injuncted, because he says under conveyance I have sold it to defendant number 3, 4, which has been restrained from further selling the portion. I said that 3, 4, they have done nothing. The order should also cover them. That's what I said on the side. Your lordship said anyway nothing. No one has filed opposition. So give them all parties time. So after that, two opportunities have been given. Your lordship also did not. Your lordship's view is that you extend it for limited portion, naturally being a commercial suit. So you extended, and twice, this has been extended. I would be praying, since no one has filed the affidavit in opposition till date, I would request your lordship to firstly confirm the order, which is there from 7th October 2021. Yes, that portion against defendant number 2. And so far as the defendant numbers 3 and 4, they have not filed any written statement, anything. They should also, there's a prayer in my application, they should also be injuncted from selling, disposing of. If they have already sold, well, I cannot do anything. This is what I sense. Now, as far as this he is concerned, he is defendant apparently in my suit, which is I am challenging against defendant number 2, 3. He is in possession of another floor in a small portion, and how it is possible, I do not know. He wants to hand it over to me, the possession, because wants to take benefit of a court order, and probably the entire mean profits, which is not been paid from 2017, he wants to, I have no, but it cannot be an order of court. You want to hand it over, I will take it, but you cannot do away with my right. Over these years, you have not paid me. He wants time, for a junior.
You are appearing for whom?
For ABCT Workers Welfare Services, my lord.
Item number 10.
Filed an application.
Item number defend number 10.
No, he says wrongly described. He says
it's not an association. What is the correct name?
ABCT Workers Welfare Services.
Welfare Services, not the association.
Well, I included that association because Standard Chartered Bank in the deed of conveyance, when it sold the property, has described this as this. So I cannot change.
But my lord, Standard Chartered Bank has issued a letter of adjournment
subsequently.
That and also to the Padmavati. My lord, therefore,
so which application you have filed? Where is your application? Application number?
Millard, he needs time because a junior is not well, Millard, so far as his application is concerned.
So you want time?
Till Wednesday, my lord. He's not
so
well.
Far,
He could
so
not
far as
come to court.
GA1 is concerned, my lord.
My lord, we have filed, we have served all the defendant, my lord. This is a affidavit of service. May I file it?
Yes. Who is for the one?
Your lordship, I'm
One.
appearing for
The one has nothing basically.
So you have nothing to do. Who is 2?
I'm 2.
You are 2. Yes. What is the submission?
No, so far my submission is so far GA1 is concerned. Well, my affidavit in opposition is ready. F1, my lord. I'm sorry, I'm out of time. I can serve copies. This is an injunction. GA1. So if liberty be given to me to file the opposition, I can file here and now.
When direction was passed?
So
direction was passed, Millard. Your lordship gave
2 extensions.
2 extensions. This is the
extended till
last
4th of March. 4th of March of my lord's order.
commercial suit is can't happen. I mean,
No, the difficulty, my lord, because of this Ramzan period, my lord, my client
hey,
gets through his
before
effort.
that,
Yeah, and, no.
hey, hey, you're now making it all holy. I mean, religious and all this. Please.
Now Ramzan has gone. Now Ram Nami.
Ram
Now you can
Navami
file.
coming.
Now you can file.
No, then I am ready to file anything.
Chaitra Shankant is there.
Chaitra Shankant. It's all in Ram. Well, if liberty be given to me to file opposition.
Well, then I'm sorry. Then, Millard,
Okay. You will file reply.
Millard, I have to. I mean, someone it will go. I mean, this is a commercial suit.
Enjoying the interim order.
How does it matter whether I'm enjoying?
Interim order expires
Till today. Interim order is till today.
Yes,
By which order?
4th of March.
Is till today.
Millard, kindly about this cost and all, kindly give leave to my junior too.
Mr. Bose made it a point and then handed over the baton.
No, what to, no, I said.
Now,
With leave of Mr. Bose, may I just refer to Your Lordship the last order that was passed on 4th of March 2025?
4th March.
Yes. By that order, the second extension was granted. The second extension was granted in favor of the defendant number 2 to file their affidavit in opposition within a further period of 2 weeks from that particular date. So he's out of time and he's taking the advantage of the religious this thing. And this was the second extension. The first extension was granted on 23rd December 2024. That earlier order by which first extension was granted. So they could not comply with this first extension. Then they sought the second extension. And now they are coming up after having violated the order of Your Lordship.
GA1 filed by the plaintiff.
Yes, that is for the injunction.
Okay.
Where the injunction is subsisting till today by reason of the order dated 4th of March 2025.
Okay. So what is your submission?
My submission is twofold. One is the extension of the interim order. And second is, let some cost be imposed on them because of this order being violated.
Okay.
And they could not file it within the time.
Okay.
Extension having been taken twice over. So I'm entitled to some form of cost.
And then I've said my submission because the only thing, my change of advocate on record, whether we are the new set.
Because this
is
is
done in November.
This is a
I must say.
commercial suit. They
And
are
this
basically
Ramzan period,
stalling
I
the progress
leave it
so
on.
far as the suit is concerned by this.
Okay, next.
And so far GA8 is concerned, GA8, my lord, is Mr. Godhod is not moving the application. Yes, I'll make.
Your Lordship, I'm appealing for Standard Chartered Bank, the defendant number 1. The main prayers are not against us, Your Lordship, but we want to file an affidavit in opposition to the GA1 application. We are out of time, Your Lordship, but we are seeking 2 weeks further time because there are subsequent events that have happened between Standard Chartered Bank and new lease deal has also been signed between the parties, Your Lordship. So kindly I request Your Lordship grant me 2 weeks further time. We are collating the documents, and this is the first time I am seeking an extension, Your Lordship.
Well, regarding Standard Chartered Bank, I'm not asking for any relief.
J1.
It is nothing to do with Standard Chartered Bank here. I mean, see the relief, Minute.
Not against you.
Yes, I know.
Respond number 2, respond number 3 and 4.
Yes.
No, but I am the defendant number 1 in the application.
Maybe, but it is not against you, madam.
No, but I want to file my
You disclose in the written, you file the written.
I have filed my
It's
written
filed.
statement, but that subsequent facts which I'm referring to, Your Lordship, have happened after we have filed a written statement. So I have to bring them on
how
record.
can it be
But
done here?
that cannot be by way of affidavit in opposition in the J1. J1 is not against you. Correct. If you want to deal with some document, there is another procedure.
There is nothing, Millard, with respect.
Procedure,
That's what
if you
I
want
feel.
to bring any document from the Standard Chartered Bank.
Sir, Your Lordship, I have instruction from my clients. They want to file an opposition.
Why the court? But Mr.
But I have not. I am.
No, but prayer D.
No, I am not. If it is against, I am not pressing.
But Your Lordship, I have to deal with them on records. Please, kindly, Your Lordship. This is the
Yes,
first
next,
time I'm taking an extension.
Oh, about the electricity bit, that has been sorted out. Yes,
I have to bring them on records, Lordship, please. 2 weeks time.
Yes, it has been
Madam,
sorted.
I am appearing on behalf of the CAC in this matter. Defendant number 7.
Yes, I am aware. That's been sorted out. He's aware. It's been sorted out. Now, yes, the other thing.
Kindly 2 weeks time, your lordship.
What purpose should we serve? Kindly,
Your
it is a
prayers
time.
are against us. This is not record that he will not press it against me.
You please record. I'm saying I'm not pressing.
You're recording no prayers against defendant number 1.
Yes, in the application, I'm
recording here. You have prayed for the time to file affidavit.
And the dispute
this court find that there is no relief as of injunction asked from you. And
yes. And the dispute with regard to electricity has been solved.
The defendant number 1.
Yes.
Grateful.
So you have saved.
Yes.
Grateful, your lordship.
Yes.
And I have filed my written statement, your lordship.
Yes, my lord, Anna, in spite of 2 directions by your lordship, copy of written statement has not been served. Has not.
We have not served. We have served you.
When? Show the acknowledgement.
Okay. Defendant number 1 has not served. And there's
I'll serve it today, your lordship.
Today you serve.
Please.
I will serve it today.
To my advocate.
You
Today you serve.
can record your lordship. I'll serve it today
Record.
over
Record.
email by the court.
Please.
I will.
So suffering for the plaintiff. So suffering for the defendant number 1. So suffering for the defendant number 2. So suffering for the defendant number 7. And so suffering for the intervener. Counsel for the intervener prays for time accordingly. On the prayer of the intervener, hearing of GA8 is adjourned. 8 of 2025 is adjourned.
Kindly also record we have filed the affidavit of service.
Affidavit and the counsel for the intervener has filed affidavit of service. Let the same be kept with the record. Full stop. The defendant number 2 has filed affidavit in opposition in connection with GA1 of 2021. Counsel for the plaintiff raised objection and submitted that 2 extensions have been granted to the defendant number 1 and defendant number 2 to file affidavit in opposition, even within the time, even in the second, even the extended time on the second, even the second extended time, the defendant number 2 has not filed the affidavit in opposition. And the affidavit in opposition is out of time. Filed by the defendant number 2 is out of time. Accordingly, cost may be imposed. Counsel for the defendant number 1 prays for time to file affidavit in opposition in connection with GA1 of 2025. Counsel for the plaintiff submitted that the plaintiff has not prayed for any interim order against the defendant number 1, and as such, there is no requirement of filing affidavit in opposition by the defendant number 1 in connection with GA1 of 2021. Full stop. At the learned counsel for the respective parties, this court find that in GA1 of 2021, the plaintiff has not prayed for any interim order against the defendant number 1, and in the court from the bar. In the court, learned counsel appearing for the plaintiff submitted they are not praying for any interim order against the defendant number 1. Accordingly, prayer for time to file affidavit in opposition in connection with GA1 of 2021 by the defendant number 1 is refused. Full stop. As regard acceptance of the affidavit in opposition by the defendant number 2, this court find that the defendant number 2 has taken the ground with regard to the religious function. The affidavit could not be filed within the time account. Thus, this court accepted the affidavit in opposition filed by the defendant number 2. The plaintiff has the liberty to file affidavit in reply within 2 weeks from date. 2 weeks from date. Let GA1 of 2021 and GA8 of 2025 be listed for hearing on 30th April. 30 April. In the counsel for the plaintiff submitted the interim order granted earlier is going to be expired today and paid for confirmation of the interim order. This court find that the defendant number 2 is contesting the interim application being GA1 of 2021 by filing affidavit in opposition, and as such, instead of confirming the interim order is extended till.
My lord, we are also praying for interim order so far as defendant numbers 3 and 4 are concerned.
Till
who have not filed any affidavit in opposition.
Till 2nd of May 2025.
And neither written statement.
Order, whichever is earlier. Yes, they are not appeared.
They have not appeared and they are not. They haven't yet filed any written statement also.
Come on the next day, we'll see at the time.
And Liberty. Yes, your lordship may be kind enough to consider the prayer that liberty may be given subsequently to the plaintiff to make necessary ask for necessary relief so far as defendant numbers 3 and 4 are concerned in the application.
As none appears on behalf of the defendant number 3 and 4, the plaintiff has liberty to make appropriate submission on the date fixed at the time of hearing of the
And let also direction be given so far as defendant number 1 is concerned that they may file the copy of their
counsel for
written
the
statement.
plaintiff submit that though the defendant number 1 has filed the written statement, but the copy has
Serve a
not been
copy.
served.
Yes.
Accordingly, the counsel for the defendant number 1 is directed to serve the copy of the written statement to the learned counsel, learned advocate on record of the plaintiff in course of the day.
Grateful.
List the matter on
30th
April under the adjourned motion.
for framing of issues, my lord, on the next day.
Hearing of injunction.
Framing of the order was also
As
there
well
in
as
the
frame.
suit.
But the written statement, the defendant number 2 filed written statement.
Yes, they have
Got
filed
in
written
instruction
statement.
completed.
Yes, not everyone has
Not
filed
everyone
the
has
written
discovered.
statement,
But
but
with
this
regard to what about the other defendants?
and our affidavit of documents is also ready.
What about the other,
I will have
other
to do.
defendants?
I will have
They
to.
have not filed their
No,
chances gone
have you
because it's a
obtained the report? Because if it is commercial,
yes,
so
it's a
then it has to be placed in the undefendant.
If your lordship will then call for a report from the
You take your advocate on record will take. Come on that day with all report. I will.
Kindly direct GA number 8 be also appear.
Yes, both applications. Both applications.
grateful.
Adjourn.
My application.
But 15, I'm appearing on behalf of the defendants, Lord.
Yes, the other side wait for time, I think.
My lords, my lords.
He's
When
having
will
some
it-
personal difficulty. Mr. Kumar is having some personal difficulty.
Yes, when Lordship then tell me.
When you will be available?
Lordship next Friday, my lords.
My lord, we can complete today, my lord.
Okay, then let Mr.
My
Ghosh
lord.
write it, or you take note of it.
My lord.
My lord, I am purely on admission, my lord.
Yes.
You know that. My lord, I am purely on admission. My lord, my admissions, my allegations, my lord, have not been dealt with. If my lord, dealt with, my lord, my specific allegations, if your lordship takes, my lord, has not been dealt with anywhere in the affidavit, my lord, in opposition, page 12, my lord, paragraph 21, 22, 23, 20
Of the affidavit?
of the, my lord, injunction application, my lord, if your lordship
Your
takes.
injunction application?
Yes.
GA1?
Yes, GA1.
Yes.
My lord, paragraph 22, if your lordship takes.
Yes.
The respondents are not dealers and distributors of the petitioner, and the petitioner has not authorized the respondent to sell, distribute, market, advertise,
Yes.
or otherwise deal with TMT bars manufactured by the petitioner,
Yes.
bearing SRMB, wind grip, X-grip, or any other goods of the petitioner. There exist legitimate reasons for the petitioner, who is the registered proprietor of SRMB, wind grip, X-grip mark, to oppose further dealing of the goods by the respondent, as the petitioner has reasons to believe the respondents have changed and impaired the TMT bars manufactured by the petitioner bearing the petitioner's registered trademark, and are mixing the impugned trademarks bearing SRMB, wind grip, X-Ribs mark of inferior quality while offering and exposing the petitioner goods in the market and stocking them for the purpose of selling. Such rights of petitioner also flows from the Trademark Act. Any person purchasing from the respondent the TMT bars bearing SRMB, wind grip, X-Rib marks manufactured by the petitioner would not be eligible for the warranty or benefits offered by the petitioner in respect of the goods sold by the authorized dealer and distributor of the petitioner, and by reasons whereof the customer would suffer immensely, and goodwill and reputation of the petitioner would be severely jeopardized and tarnished, resulting in dilution of the petitioner's registered trademark, SRMB, wind grip, X-Ribs trademarks. Now, paragraph 25. The wrongful and illegal sales of the X-Ribs bars by the respondent without the consent and approval of the petitioner results in inducement of breach of contract, tortious interference, etc., etc. Now, my lord, how he has filed an affidavit in opposition. We are, my lord, before the court of law. Now, my lord, in his affidavit in opposition, if your lordship takes, my lord, it's an affidavit filed by. I'm only going by, my lord, his admission, my lord. At least in the ad interim stage, I am also entitled to such, because there is no 6th of December 2024 by Mahesh Agarwal. Now, my lord, kindly have a look at his affidavit. This is an affidavit in opposition. Lordship will take
only till 12.
Yes, my lord. 6, my lord, he says, my lord, legitimate procurement and resale of TMT bars. So there is no unauthorized sale of the products.
Para
That
6.
my lord, I have terminated. Para 6. That's his case.
Yes. Involve the legitimate procurement.
Yes. Then my lord, para 7, I am trying to single him out. Then para 8, market dynamics. Para 10, concealed material facts. Then my lord, para 12, surmises. Para 12, surmises and conjectures. Trap cells, I am within, my lord, so I can sue for infringement within. So there is no question of trap cell. It's, my lord, a solitary cell, my lord, where, my lord, jurisdiction of the court is trapped by means of the cell. Para 13, the para 13, if your lordship takes, my lord, which is only said, the plaintiff, through the present suit, has failed to disclose the fact plaintiff was aware of the petitioner respondent acquired the products of the plaintiff's own dealer and is selling the same in the market without any changes or impairment. So, my lord, is my reasonable belief? I say, my lord, he is changing. He says, I am not changing. So, my lord, how, my lord, he is selling? There is no particulars, my lord. So, my lord, and my specific denial has not been dealt with. Then he gives the language. Then, my lord, he tries to argue law. The last four lines, the language used in section 30 read with section clearly indicates if the goods are lawfully acquired by the person for the purpose of resale, these goods have already been placed on the market by the proprietor with the consent, such do not constitute an act of infringement. Now, my lord, this is what he has given. Now, my lord, if your lordship takes para 9, the invoices of procurement, my lord, para 14, page 9, my lord, kindly take, my lord, Mishra Steel is serial number 124, 127. Then page 10, BK Associates, 1 to 4. So these both we have, my lord, terminated. So, my lord, these two lawful sources are not there. Now, my lord, if it is not there, my lord, if he is doing from someone else, then, my lord, in all fairness, my lord, if he is also doing from there, in judgment of Kapil Wadhwa says, my lord, he has to give that undertaking. Now, my lord, this is, I go by his admission, my lord, and he's dealing in the paragraphs in question. Now, if your lordship kindly have a look at where we stopped the judgment of, my lord, the English court, I stopped. My lord, kindly have a look at the judgment in question.
Yes.
Your lordship, I have given the judgment, my lord, of the UK Supreme Court, my lord. Has lordship has a copy of it? Last time I gave it. My lord, I stopped. My lord, kindly have a look at. Straight away, lordship comes.
Para 10.
Para 10, my lord, without the consent of the proprietor. Now, my lord, kindly take para 11. The offences set out in paragraph A, B, C of section 92 are as a plain reading of are not cumulative but separate. It is not necessary that one has been committed by someone before one can say next in line has been. The mental element with a view to gain or intent clause laws is applicable to all three. So the element of use of the sign is without the consent of the proprietor. Paragraph A then makes it an offense to apply to such mark without the consent and the relevant mental element. Paragraph B makes it an offense to sell the goods with the mark without consent of the proprietor with the necessary mental element. Paragraph C does not have the same preparatory offense in possession of the business with a view to the behavior would be an offense. Now, my lord, B again. Last, of course, a person may commit all three offenses of different people, may commit all three between them, but it is not necessary each standalone. Now, lordship will kindly straight away come to paragraph 18. Middle portion. The possible difficulty of distinguishing where there has been an overrun between the goods marketed with the proprietor's authority and those with the backdoor venture on the manufacturer and subseller might as well be both on the construction. No doubt in many cases of circumstances exist from the factory of subsequent sale will often be telling. Now kindly take likewise, it is far clear that will greater difficulty occasioned by the appellant by suggesting construction that by correct one in convincing the fakes. In both cases, defendant may occasionally be in a position to assert that he was taken in and reasonably believe that no infringement was involved. But such a defense is advanced would be met on its merit. It will no doubt involve investigation, inter alia the circumstances in which the defendants acquired the goods and inquiries which he did or did not make. But these constitutional arguments apart, it is on any view unlawful for a person in a position of the defendant to put grey goods on the market, judge it is a fake ones there, but may involve deception of buying the public. The grey market goods may be such that they're defective. The distinction between two categories is no beans is cut and cried. Both are in any event clear infringement of the plaintiff's right of the proprietor. The defendant would set up the grey market and make profits on resale to do because object is someone else trademark. If it is proved that they may be sent claim of the beneficent construction of the act, and it is ordinary reading and plainly meaning unless there is statutory defense have committed such a defense. The 19 Miller, kindly take the last portion. Last portion, Miller, 1994 Act, Miller, 10 lines from top. The 1994 Act does not deprive the defendants of any property which they have. The most it does to regulate their use or the manner of the disposal of the good which is permitted under second paragraph Article 1 in general interest. They must include general interest in protection of the mark. In any event, nothing disappropriate in 1994 Act penalizes sales when infringing by still attracted, not imposing a criminal sanction on those otherwise called the liability in damages worth taking. It's perfectly legitimate balance drawn between the rights of the proprietor to valuable product, trademark, goodwill, and those of another who wishes to sell the goods brought. So, Millard, some checks and measures has to be brought. And Millard, if Lordship is with me is one thing. If Lordship is not with me, Millard, there is also Millard Justice Naveen Chawla's judgment on this, which I have already Millard placed, following Kapil Wadhwa and Millard basically distinguishing Kapil Wadhwa, saying Millard in this type of infringement cannot be permitted. This is Millard Western Digital's case, Millard. If your Lordship takes Millard, Justice Naveen Chawla, a decision Millard, Western Digital versus Raj Computer. We have given a copy, Millard, if it is at the time of moving. Just one paragraph and I conclude. That's it. This is Millard, Western Digital Technologies versus Raj Computers.
Yes.
Lordship will straight away come. Para 24.
Yes, so relied upon 25.
Yes, 25.
Yes.
I have relied upon 24, 25. Millard, I want to show Kapil Wadhwa is quoted, clarified and explained. Paragraph 22.6. Amway is considered in paragraph 27. Where it has held the doctrine of exclusion does not give legitimacy of tampering. Paragraph 27.
Yes.
Of tampering and mutation of products. Applying these above, the plaintiff has been able to prove infringement in its trademark of the defendant and an injunction order was passed. So, Millard, Kapil Wadhwa has been explained. It is not something, Millard, order has been vacated. Order has been, Millard, modified because he was purchasing, Millard, from the Korean company and selling in India. Yes. But, Millard, warranty Indian company is not going to give. He has to give a disclaimer as mandated in Kapil Wadhwa.
Yes.
If that is the situation today, Millard, then Millard, of course, Millard, this after Millard non-denial or Millard, basically why it is there is no tampering and how he is selling, if he has not explained in the affidavit, Millard.
Yes.
And it's very basic. My junior wants to show Millard, I think it's very basic. That non-traverse is basically an admission, Millard. That's paragraph 26, Millard. 23 to 26, 2024, 4 SCC 727. Lordship, it's very basic. So, Millard, I proceed on the basis of his admission in the petition.
Yes.
There is a positive statement, but Millard, no explanation. That he says, I say that I, Millard, kindly Millard, appreciate. This section is legitimately believe. That's the section language. It's not actual, actually it has to be done. This section is, I have a legitimate apprehension. Para 4, if your Lordship takes subsection 4 of section 30, look at the language in question. Subsection 3 shall not apply shall not apply.
Section.
30 subsection 4. He is relying on subsection 3.
Yes.
I am relying on 4. Subsection 3 shall not apply where there exists legitimate reasons for the proprietor to oppose further dealings of the good in the particular case where the condition of the goods have been changed, impaired after they have been put into market. So I have a legitimate reasons to believe. There should be something in actual, but legitimately, legitimate. I believe he has to then dispel that by giving cogent evidence, which is absent, Millard, in the affidavit.
Yes.
Why my legitimate reasons to believe? Because as on date, Millard, 2 of the dealers from which he was acquiring the product I have terminated.
Cancelled.
So that in this context, Millard, I'll be praying for an order of injunction. If Millard, Lordship is of the view, Millard, subject to correction, that no, I'll not give the full injunction I have passed. This is my second argument. Then Millard, a disclaimer is partial injunction as Millard provided in Kapil Vadva division bench has to be passed. There can be a blanket free rider. That's my respectful sir.
Thank you. Consistency opening for the plaintiff, consistency opening for the defendant. Counsel for the plaintiff has concluded his argument in connection with GA.com 1 of 2024. Counsel for the defendant prays for time. Accordingly, case adjourned. Let the matter appear on when? 11th?
11th, my lord.
11th April 2025 for hearing. Yes, under the same heading. Yes, next.
Extremely good.
Yes.
That will conclude today. My lord, this matter, your lordship was hearing me on last occasion, my lord. This is in respect to a recalling application filed by the defendant. In respect to my lord, and plaint was served in the open court, my lord. So dispensation of service was recorded, but after that they have filed a recalling that they were never served. So that was the point taken by one defendant. They are recalling application, lordship will kindly take my lord.
GA4.
GA4.
Yes.
Lordship will kindly take my lord. Well, I have on last occasion I have just given a brief note so that well it can be related from the page numbers and that. Now, if your lordship kindly takes my lord paragraph 4, page 2. Well, I'll just read some paragraphs and their prayer, then I'll come back.
Paragraph 4.
Yes, sir. They are application GA4, my lord. The defendant had no knowledge of the filing and institution of the suit until 7th September 2022, when the defendant received an email purporting to be notice from the learned registrar mediation of the Honorable Court calling upon the defendant to participate in a mediation purportedly relating to a pending suit before the High Court, being CS 131 of 2020. The notice, however, referred to the erstwhile name of the defendant company. A copy of the said email is annexed here. Well, now lordship will kindly comes to my lord. Yes, 5. Well, immediately the defendant instructed its advocate in Kolkata to take steps and to carry out necessary inquiries into the matter. It was upon the defendant's advocate making necessary searches and inquiries that the defendant learned of the pendency of the present suit. From such searches, the defendant learned of the following. By an order dated January 5, 2021, this Honorable Court was pleased to admit the plaint by granting leave under clause 12 of the latest patent. By an order dated 30th August 2022, the plaint sought to refer the matter for mediation, and such direction was accordingly passed by this Honorable Court. Now, paragraph 6. The defendant instructed his advocate to appear and participate in the said mediation for and on behalf of the defendant. The defendant also caused its advocate to appear before the Honorable Court on 5th December 2022, 9th January 2023, and 15th February 2023 to apprise the Honorable Court as to the status of the mediation process. By an order dated 15th February 2023 of this Honorable Court, recorded that the mediation has failed and matter was not settled at this stage. On or about 30th March 2023, the advocate of the defendant, unaware of the intentions of the plaintiff, filed wakalatnama along with an affidavit of competency, wherein also the correct address of the defendant was mentioned. Despite directions of this honorable court, the plaintiff did not serve any copy of the plaint or any documents upon the defendant, and such fact is evident from the order dated 27th February 2023. Yes. On March 13, 2023, the defendant's advocate brought to the notice of the Honorable Court that the defendant's name has been changed in the year 2019 from Crest Logistics and Engineers Private Limited to CLE Private Limited. The plaintiff thus sought time to amend the cost title of the plaint, and this Honorable Court permitted the plaintiff to take appropriate steps. After some delay as recorded, the plaintiff filed an application being IAGA number 2 of 2023 seeking amendment of the cost title of the plaint. The said application was allowed without inviting affidavits by an order dated May 18, 2023, and time to carry out such amendment was extended by the order dated July 2024. So, my copies of the amendment. Now, my lordship will kindly take my lord page yes. Yes, page 5, paragraph 11. The suit appeared in the list of Honorable Justice Krishna Rao on August 17, 2023. The plaintiff's advocate handed over. Now, I am just pressing on this paragraph. The plaintiff's advocate handed over a copy of the amended plaint to the advocate of the defendant. The advocate of the defendant, not having the opportunity to scrutinize the amended cost title of the plaint or take instructions from the defendant, accepted the copy of the amended plaint during the said hearing. In such circumstances, this Honorable Court recorded that notice of the amendment plaint has been accepted by the defendant and dispensed with filing fresh suit writ of summons upon the defendant. Upon scrutinizing the amended plaint and upon taking instructions from the defendant, the advocate for the defendant first learned that the address of the defendant mentioned in the cost title of the amended plaint was incorrect. Now, my lord, so their case is that, my lord, when this plaint was served, pursuant to the order of your lordship, my lord, it was filed, it was served in the open court. Well, I am taking the situation on that way only. So it was served on the open court, my lord. So the honorable, the learned advocate, my lord, could not go through the cost title, my lord. And so, my lord, after going through the cost title, my lord, this recalling application has been filed. Whatever. Now, my lordship will kindly takes, my lord. I am on a very specific point, my lord. My argument is only based on two things, my lord. First thing is that their knowledge, their acceptance was legal. Why? Because they received they have already, my lord, filed the wakalatnama prior to the acceptance, and after acceptance, my lord, period of 9 to 10 months, my lord, was elapsed when they have filed a Section 8 application, my lord. Section 8 application, they have specifically stated that after perusal of the plain, my lord, they have drafted the Section 8 application, and it was a contested one. My lord, your lordship, yes, they have given an they have contested, my lord, when the Section 8 was dismissed, my lord, they came before this Honorable Court. Order has been recorded, my lord, wherein they prayed before the Honorable Court that we are going to prefer the appeal. After that, man, in an interlocutory application, when the injunction was going to be moved, my lord, they appeared. They appeared and said that I will file an objection and also written statement to be filed. So, my lord, my contention is based on that. Today, you are coming before a court for recalling of an order. Two basic things, subject to correction by your lordship, whether there is a fraud practice on the court or whether I have suppressed in respect to such, I am getting an order which is prejudicial to their interest. Why? They were present since the mediation process was on. In the mediation process, my lordship knows, my lord, it was served and the cost title was very much, my lord, there in the notice. They have accepted that through email, my lord. They have stated in their opposition of this application also. They appeared after filing wakalatnama on 30th March. And they received the plaint when in the open court. So, if after receiving the plaint, if they could have come and they said, yes, recalling has to be done or anything that this order. So, that's a different thing out there. They contested, they appeared. Learned lawyers argued on respect to the jurisdiction point for 4 to 5 days. But after that they come, so my lord, the statement made in the recalling application, contrary to the records, and my lord, if this statement is there in the my lord, recalling application, but my kind my lord, humble submission, my lord, then this application cannot be allowed.
Okay. That's all.
No, no. Well, I'll take lordship 15 to 20 minutes. Now, my lordship will kindly take, my lord. Well, I have given a note of before your lordship, my lord. Lordship will kindly take the page if your lordship can, my lord. Well, page 68 is the first page, my lord. I'll be relying only to show that, my the mediation process.
Page 68.
Yes, my lord. Yes. Well, in my note also, I have given the page 7 September 2022. It's page 68. Yes. Now, only my lordship kindly peruse it, my lord. In this this notice was served, wherein, my lord, the second, my lord, and also at Shakespeare Court, flat number 5C20 was Shakespeare Sharoni, Kolkata 17. That was there. And why that was there, my lord, I have produced, I have given an objection in my objection, my lord, I have specifically given all the bills which was, my lord, accepted by the office, and, my lord, most thing is that they have paid. See, it's not a case that they have accepted and they have not paid. So they have paid. So, my lord, in respect to, my lord, that, my lord, for that reason, my lord, this leave was granted under clause 12, my lord, that they were carrying on business on that point of time. Now, my lord, lordship will kindly take, my lord, page 80. 80. So, my lord, this is an open court order. They have also stated in their application.
Yes.
So, my lord, mediation, my lord, lordship will kindly sees, my lord, I appeared, and, my lord, for the defendant, Mr. Jishnujit Roy. It found from the record that video order dated 30th August 2022, this court has referred the matter to the media for settlement between the parties. The register original side has submitted the report wherein it reveals that the mediation is in process and requires further time to complete the mediation. Counsel for the respective parties have also submitted that mediation is in process and there is a chance of settlement between the parties. So, my lord, the advocate was always represented. It's not a case, my lord, that the advocate was never represented and there was no cost at all. Now, my lord, lordship will kindly takes, my lord, 72 and 73. Yes, পরে দেখাচ্ছি ওটা। মানে 72, মানে only I'll show that they have filed the Vokalatnama 30th March 2023.
Yes.
So, 72 and 73 is over. Now, lordship will kindly takes, my lord, 27th February 2023. This is the order at page, my lord. Lordship will kindly takes. Yes, page 84. So, 27th February 2023 order.
Yes.
Now, lordship will kindly takes, my lord, last portion.
Yes.
The plaintiff is directed to serve the copy of the plain documents along with the connected applicants to the advocate and record of the defendant. Within the why this, my lord? Because they appeared previously in the mediation process. On the basis of that, your lordship has passed this order. Now, my lordship will kindly see let the matter appear on 10th March 2023. In this case, my lord, what has happened, my lord? We yes, paragraph 9, page 94, paragraph 15. This is our application, my lord.
94.
Yes, it's an affidavit, my lord. Yes, page 94, paragraph 15. The lordship directed for service. Now, my lord, that eventually on March 3rd, 2023, the learned advocate on record of the petitioner was served with a letter issued by Sina and Company advocates purported to be legal representative of the defendant. They were indicating that the name of the defendant had been changed from Crest Logistics and Engineer Private Limited to CLE Private Limited on and from December 9, 2029. So, my lord, after that, my lord, so, my lord,
what application is this?
This application, this was, my lord, it's an amendment
application.
Yes. Yes, it starts from page 89.
Page 89.
Yes, it starts from page 89. My relevant paragraph I am showing before Lordship at page.
Who has filed this?
This is us, by us.
You,
Yes.
defendant.
Yes.
Yes.
So, my lord, why I am showing this paragraph?
You are for the plaintiff.
Yes. Why I am showing?
It's filed by the plaintiff. Yes.
Well, why I am showing this paragraph? Lordship directed me to serve on the learned advocate on record. Well, when I sought to serve them, my lord, they get us a new information. No, next time. So, my lord, they've sent us a letter and said, my lord, that the cost title has to be changed in respect to the name is concerned. Now, your lordship knows that, well, after that amendment was sought for, well, without any objection, as it was a formal in nature, in the open court, the order was passed when the learned advocates of both the parties were present.
Open court কথাটা বলেনি, closed court. Does court do anything beyond open court?
Naturally, sir.
Court doesn't do
Anything beyond that. I correct myself in that case. So, yeah. My lord, in that case, my lord, the order was passed, and my lord, the amendment was carried on. Now, why I am trying to show this order? Because they have not filed a recalling in respect to this order is concerned.
Which order?
27th February 2023.
27th February.
Yes. Well, page 84.
Yes.
So, page 84's order, in my respectful submission, once they have taken a point that the service cannot be done on the advocate on record or whoever may be, my lord, this order ought to have been recalled. Because there was a specific direction to the plaintiff to serve on the advocate on record based on the previous records, as each and every occasion the advocate had appeared for mediation process. And after that, my lord, on our specific statement has been made in para 15 of page 94 that when we went for service, Lordship will kindly see February 27 February 2023, Lordship directed us to serve, and the matter is to be returnable on 10th March 2020.
What is the application number? That is page 89?
Yes, my lord, I'm showing you. My GA number to the this is an amendment application, my lord.
Where is that?
Yes, GA2.
GA2.
Yes, page 99, your lordship will kindly see that is GA2, page 99.
GA2. Where is the master summon?
Yes.
What was the prayer here?
Yes, lordship will kindly see, my lord. Yes, page 85, lordship will kindly see. 86.
Addition or amendment as indicated in paragraph 17 affidavit of support. Yes.
Now, my lord, my contention is that, my lord, so this 27th February 2023 order, my lord, ought to have been recalled. Because there was a specific direction, and my lord, after that, what has happened, we have specifically stated that we went for service at page 50, my lord, page 94, paragraph 15. Because the lordship directed to serve within a week. So, my lord, we went for to serve them. Now, lordship will kindly see, well, we have specifically stated on that. The learned advocate, that eventually on March 3, 2023, the learned advocate on record for the petitioner was served with a letter issued by Sinha and Company Advocates purported to be legal representative of the defendant. They are indicating that the name of the defendant had been changed from Crest Logistics and Engineers Private Limited to CLE Private Limited on and from December 9, 2029. So, my lord, whatever may be.
So what has happened to the GA2 dispose of? By which order?
Yes. Lordship will kindly see, my lord. Then, my lord, 27th, after 27th March, it came at page 100. And page 100 in open court, my lord, they have submitted. Sorry, sir. I correct myself.
Yes.
Well, a counsel for the Defendant submits that the suit was filed in the year 2020, but the name of the defendant has been changed in the year 2019. Counsel for the plaintiff submits that plaintiff will take appropriate steps for change of name of the defendant at praise for 2 weeks' time. In view of the submission made by the counsel for the respective parties, let the matter appear on 29th March 2023. So, Mala, in the court, Mala, they have specifically stated that as Mala, the name has been changed, so it has to be brought before the court. Now, Mala, Loshu will kindly seize, Mala, page 102, order dated 18th May 2023.
So this is March 13, 2023.
Yes, because
Correct.
Lordship directed on 27th February the matter to be returnable on 10th March. But at the matter.
So after 13th March 2023, you filed the GA2.
Yes.
You filed the GA2.
Yes.
And where is the order?
18th May
18th May
2023.
2023.
Yes, 102. The counsel for the respective parties are
GA2 is
present.
disposed of.
Yes. Praying for amendment of the name of the cost title and some other pages as reflected proposed amendment. Counsel for the defendant submits that the amendment as sought for by the plaintiff is formal in nature. So it was not objected, Mala, and it was allowed.
Yes.
Now, Loshu will kindly takes page 105, order dated 17th August 2023.
That is the impugned order.
As also yes. I mean, so this is the impugned order. So in my respectful submission, my lord, this order was passed after that 27th February 2023 order has not been challenged. Now, my lord, this order has been challenged after a span of 9 months. That will be evident from, my lord, page 12 of the application.
2nd July 2024.
2nd July 2024. So, my lord, what has happened in the meantime? It's not a case that on the next date they come or before previously they come with an application for recalling. Now, my lord,
after 17th August, what has happened?
Yes, that is my. Yes. But after that, my lord, they have filed an application under Section 8 of the Arbitration Act for jurisdiction that this suit is not that they have to be sent for the arbitration. Now, my lord, on last occasion, I have just, my lord, supplied a xerox of the 3 pages, my lord.
Written notes.
Not written notes, my lord. The Section 8, the xerox of the Section 8. Yes.
Yes.
Yes. Now, Lordship will kindly seize, my lord, just to show before your Lordship. After this, they have filed this application on 12th October 2023. Now, my lord, the first paragraph I was just relying before your Lordship, my lord. Paragraph 2, paragraph 1. Page 2, my lord, paragraph 1.
Yes.
On August 17, 2023, the plaintiff has also been served with a copy of the amended plaint filed wherein the plaintiff has allegedly claimed as follows. Now, this is the thing. Now, paragraph 2, page 3. From a perusal of plaint, it appears that the plaintiff relies on the general conditions of contract. I'll stop here, madam. From the perusal of the plaint. Now, Loshu will kindly take this statement along with the statement in the recalling at page
11 and 12. Para 11 and 12.
Yes, 11 and 12. So, their case is that they have received the plaint in the open court, in the court, and after that, my lord, it could not be scrutinized at that short point of time. So, it was scrutinized. They have decided to file a Section 8 application. It was a contested one. 4-5 dates, it was contested. They appeared. After contested, they also appeared before the court and said, I will prefer an appeal. Then they said, they will file an objection to the injunction application. Then they decided, my lord, that I have to file a recalling that in respect to the service is concerned. My submission in respect to that, my lord, they have accepted this. 30th March 2023, my lord, they have received the wakalatnama from their client, and my lord, they have accepted the service. They have contested in Section 8 thoroughly, my lord. It's not that, my lord, they have on the next date they have come. They have not challenged the order dated 27th February 2023, which your lordship has specifically directed to serve on the advocate record. So, my lord, in my case, this is a case where they have accepted. And it is not a case that they will come with a recalling that a fraud has been played on me. Well, each and everything was before on the record. The lawyers appeared in each and every date. Well, and they have seen the plaint, they have drafted the Section 8 application, everything was done. So today, Mala, they cannot come and say the service was not affected when as per the rules. Now, Mala, in respect to this, Mala, I'll cite a judgment on that, Mala. Before that, Mala, Section 20 of the Code of Civil Procedure, read with clause 12 of the latest patent matter. If your lordship sees the last place of business matter, why? No objection that they only one, yes. If it takes my objection matter, I have specifically stated that yes, at page 14, para 14 page 7, into my affidavit in opposition to the this
Yes.
GFO.
Yes.
Page 7, paragraph 14. That with reference to the statements in paragraph 7, paragraph 13 to 18, under reply 7, extend to what are matters of record. Now, I'll just read the relevant part. I will not, It is denied that at no point of time the respondent had his registered office on carrying on business in Shakespeare Court, flat number 5C21, Shakespeare Sharoni, Kolkata 17. In this context, it is stated that it will be evident from tax invoices dated 19th April 2014, 11 June 2014, 24th July 2014, 5th December 2014, 20 January 2015, 2015, 26 March 2015, 24 June 2015, so and so manner, that all such bills and or invoices were raised by the plaintiff at the said above mentioned address at Shakespeare Sharoni, which were duly received by the defendant without any objection as evident from the said invoices, and also made payments and part payments in respect to those tax invoices without disputing the address and contents of those invoices, and such payments will be evident from the ledger account as maintained by the plaintiff with the defendant in respect of the work order being the subject matter of this instant suit. Copies of the invoices at ledger account. Now, lordship will kindly see. I'll just give 1 and 2 examples of the paragraph. Yes, page 15, my lord. 15, 16, my lord, all I have given the bills.
See, with regard to this address, there is no dispute at all. Correct. Only here the question, they have taken the plea after the order dated 17th August 2023. Writ of summons was not served in the correct address. Subsequently, they have verified and found that in the plaint the correct address is not there, and they do not file that, and acceptance of the writ of summons cannot be, so the writ of summons may be issued. This is the main. They are not denying with regard to this is not the address, this is not the address. That is the only point, whether after the 17th August 2023, when this court has allowed the amendment and they have accepted the written statement, accepted the plaint, and this court has waived the lodging of a writ of summons, whether that is to be recalled on what ground. That is only
because they are taking their right to file a written statement has been forfeited. So in that case also, my lord, when they appeared, they have also paid for filing a written statement.
correct.
So from that day, if your lordship also sees that time also has been, my lord, lapsed. So my lord, today, my lord, after 30 days, my lord, any date, my lord, any time, my lord, you have to give reasons for that. My lord, may I ask this question to myself, my lord? If a litigant, my lord, is not, my lord, coming in clean hands before the court, why? My lord, because they have accepted each and everything, they have appeared, and my lord, acceptance of summons by the learned
That
advocate.
is the only question. That is the only
That
question.
is the question, because they
After the order passed by this court, when the court has allowed the advocate on record of the defendant accepted the written statement, whether that written
Writ of
accepted
summons,
the writ of summons, and this court has waived, whether that is enough as a writ of summons, the issuance of the
yes,
writ of summons, or the press writ
yes.
of summons.
My respectful
That is the only
submission, yes,
question.
my respectful submission, you have accepted it, my lord, after filing of Vokalatnama, so you are quite eligible to accept such.
So
And
that
as
is
per the
all the
rules
things
is
on
concerned.
record.
Yes, the advocate on record.
Yes.
So, my lord, if
what judgment you relied upon?
yes, my lord, I will be, my lord, first relying on it as a 15 to 20. No, এটা পড়ে দাও, yes, এটা না, এটা না, আরে যেটা লাস্টে এইটা yes. Yes. Mala, this is 2009 volume 2 SCC page 703 Mala. What paragraph? Mala, paragraph 4, 5. The 2009 page 706. But this is on point of recall. Now, Lordship will kindly seize, my lord, paragraph 4. It is a basic principle of justice that no adverse order should be passed against a party without hearing him. This is the fundamental principle of natural justice and it is a basic canon of jurisprudence. In the 7 judges constitution bench of this court in A.R. Antulya versus R.S. Nayak, it has been observed that para 55 thereof, my lord. So also the violation of principles of natural justice renders the act as a nullity. One of the council relied upon another 5 judges constitution bench decision in Rupa Ashok Hajra versus Ashok Hajra. It is true that in para 9 of the judgment it has been observed that this court under article 32 of the constitution cannot hold as a valid cannot hold as invalid a judgment of this court by treating it as a nullity. However, the aforesaid judgment does not say that we cannot pass a recall order when the order has been passed without hearing a party. There is a distinction between a petition under Article 32, a review petition and a recall petition. While in a review petition, the court considers on merits where there is an error apparent on the face of the record. In a recall petition, the court does not go into the merits but simply recalls an order which was passed without giving an opportunity of hearing to an affected party. In my respectful submission,
That's what I'm telling. This is the only point.
this is the point.
Because
they have
going
accepted.
this document, that down, that
Yes.
court cannot.
So, Mala, Lordship has I'm clear. The Lordship. Now, in respect to Mala, paragraph 2006 volume 12 ACC page 119 Mala. It's an waiver, paragraph 90. Abstain. Well, I am just citing Mala. This is 2006 volume 12 SCC page 119 paragraph 19. This is also Mala. Ah, 2000 action.
2006. Paragraph?
Paragraph 90. I'll be reading or your lordship? Let me see.
Yes.
In this case, there was a procedural lapse also, but the service was accepted. So, on this lordship will can.
Yes, then that's all.
Yes, another.
Anything further?
Sunil Poddar is there. 2008 volume 2 SCC page 326. 2008 volume 2 SCC page 326. Paragraph 23, 24, 25, 26, 23, 24, 27. Yes. 20 থেকে শুরু করি।
Yes.
কত বললাম 23 it is therefore clear that the legal position under the amended code is not whether the defendant was actually served with the summons in accordance with the procedure laid down and in the manner prescribed in order 5 of the court, but whether he had notice of the date of hearing of the suit and whether he had a sufficient time to appear and answer the claim of the plaintiff. Once these two conditions are satisfied, an ex parte decree cannot be set aside, even if it is established that there was irregularity in service of summons. If the court is convinced that the defendant had otherwise knowledge of the proceeding and he could have appeared and answered the plaintiff's claim, he cannot put forward a ground of non-service of summons for setting aside ex parte decree passed against him by invoking Rule 19 or 9 Rule 13 of the court, since the said provisions applies in the date recovery. So, my question is that even if they are defective of service, even they have knowledge. So, even in a situation of order 9 Rule 13, the court is saying that you cannot come.
You cannot.
Well, you cannot come on the basis of the service if knowledge is the main thing, knowledge. Well, I am on the knowledge. Knowledge, and in this case, acceptance that they have accepted each and everything. Well, another two judgment I'm not citing, if that Justice Bhaskar Bhattacharya in that Colgate Palmolive matter, 2000. Well, I'm just not, because this is the entire judgment, then I have to read. 2011, 4 Calcutta Law Times, page 139. Sorry. Paragraph. Last paragraph. It's the impugn. The page is from. There is no marking in the paragraph, in this case. Third last page, it starts from in the case before us. And the facts.
Yes.
So this is in respect to a situation, madam. And my lord, if my as per my knowledge goes, my learned senior friend has not cited any decision in respect to that.
He had not, but
If my learned
what I was suggesting is that, my lord, since I will have to come, I'll call some other day to give a reply. Let him consider these two judgments, and if he wants to say, give him 5 minutes.
This is Delhi High Court judgment. I'll take care of this.
Two judgments are there, my lord, where the court has taken care of what should be the interpretation under the Commercial Courts Act.
Very well. So my submission is
kindly give him an opportunity to deal with it.
very well.
So appearing for the plaintiff, so appearing for the defendant. The plaintiff in connection with GA Form 4 of 2024 has concluded his argument. Full stop. Counsel for the defendant has handed over to judgments which the defendant relied upon. Accordingly, the plaintiff has liberty to deal with the said judgments on the next date fix. List the matter on 10th April.
Yes.
10th April for
Yes,
hearing of GF under the same heading.
Careful, man.
Item number 17.
Lord, I'm appearing for the plaintiff in this matter, my lord.
Yes.
The two applications are on board today, GA6 and GA7. GA6 and GA7, my lord.
What is the GA6?
GA6, my lord, is my application under Order 13A of the Commercial Courts Act. My lord, in one of the suit with regard to the same defendant, your lordship have decided this issue with respect to the same transaction. So, my lord, your lordship had passed an order on 7th of January 2025. Lordship had rejected the application. This was the order passed.
You are for the plaintiff?
I am for the plaintiff.
Nobody is appearing for the defendant?
Yesterday, my lord, I could not appear. Defendant was there, so it was made not today. Lordship can pass a similar order, my lord, if your lordship desires.
An order declaring the suit against the defendant in terms of prayer made in the plaint.
Since this plaintiff was merged with another company, so I had taken out an application for amendment. So that is why this was not decided. Otherwise, my lord, this should have been decided with the same.
Both applications ready?
GA6 can be rejected because it has been decided by your lordship with respect to the same defendant in an identical transaction, one of the group companies. In another,
that has been rejected by this court. Order 13.
Order 13, my lord. This was the order passed by your lordship with regard to the same defendant. I cannot come in the way, my lord.
Acha, this one.
Yes, my lord. So
It's
like,
connected with the same.
this was merged with another company, so I had to take out an application. So this was not decided. So this has come today. So this can be rejected in terms of this order also, my lord.
But other side is not.
My lord, okay.
So and so appearing for the plaintiff. None appears on behalf of the defendant. Counsel for the plaintiff submitted the application filed by the plaintiff being GA-Com 6 of 2024 has become infectious in view of the order passed by this court in CS-Com in GA 6 of 2024.
And may I? Lord, instead of being highly infructuous, Lord, it can be rejected in terms of that order. Lord, this court has decided.
No, not infructuous. Get it in? So appearing for the plaintiff. The plaintiff has filed the present application being GA-Com 6 of 2024. Where is the GA-6? Manatosh? Acha, ye hai. Praying for a decree in terms of prayer made in the plaint, along with the interest and other expenses. Full stop. This could find that in the similar matter, in the case of KP Credit and Traders Private Limited versus Ashoka Hawaii and Suez Private Limited, being CS-Com number 353 of 2024, within bracket old CS number 40 of 2022, 2024. In GA number 6 of 2024, this court has rejected the similar prayer made by the plaintiff in the said suit. The order passed by this court dated 7 January 2025 in the above mentioned matter is squarely applicable in the present suit. Accordingly, in view of the above, CS-Com 6 of 2024, CS-Com 6 of 2024, sorry, GA-Com 6 is dismissed. Is dismissed. With regard to the GA8,
GA7, my lord.
GA7.
GA7 is also my application, my lord. I had taken out this application to take off the record the written statement, my lord, on the ground that it was filed beyond 120 days. My lord, the mistake was on the part of the advocate on record who had given the consent. So, my lord, on that premise, my lord, the WS written statement was filed, my lord. I'm sorry. So, my lord, I have taken out an application relying on a judgment of the Honorable Supreme Court.
Let the other side come.
My pleading that not complete my direction.
Plaintiff has also filed an application being GA7 of 2024, praying for recalling of the order dated 12th of April 2024, passed by this court. Full stop. As none appears on behalf of the defendant, none appears for the interest of justice, the case is adjourned. In the meantime, the parties are directed to exchange their affidavit.
Of service be taken.
Exchange their affidavit. Affidavit of service filed by the plaintiff be kept in the record. Let the matter appear. Let GA-Com 7 of 2024 appear on 6th of May 2024 for hearing.
One indulgence, my lord, due to an inadvertent mistake, the order which I have recalled is not annexed in the application.
The plaintiff prays leave to submit that though the plaintiff has filed an application being GA-7 of 2024 for recalling of the order dated 12th April 2024, but inadvertently the said order is not enclosed with the present application and prays for leave to file supplementary affidavit by disclosing the said order. Accordingly, plaintiff is granted leave to file supplementary affidavit by disclosing the order dated 12th April 2024 in GA7 of 2024 within a week from date after serving the copy to the Senate Counsel for the defense.
Grateful.
Number 18.
In this matter, I am for the defendant.
I am for the plaintiff, my lord. Mr. Garg is appearing in this matter, and I have been requested by Mr. Garg that today I should take adjournment.
What is the matter?
So it was my application for amendment of written statement, lordship. They my lord filed an opposition against it, my lord. We filed reply on the my lord on the earlier day, my lord. Mr. Gorg, my lord, sought for time for considering the reply, my lord, the contents of it, and then come back, my lord. He is not there.
Today he is stuck somewhere else.
So appearing for the plaintiff, so appearing for the defendant. As per the prayer made by the counsel for the plaintiff, case adjourned. Let the matter appear on 24th April. Under the same heading. Next.
Number 19.
तो लास्ट ऑर्डर क्या हुआ मनोतोष इसमें लास्ट ऑर्डर क्या है 16 दिसंबर 2024 के बाद कोई ऑर्डर नहीं है लास्ट ऑर्डर है पक्का क्या एप्लीकेशन नहीं है इसमें तो इंटरिम ऑर्डर टिल 4th फिर उसके बाद क्या होगा रेस्टोरेंट फंड डीलिंग में इनकम्बरिंग उसके बाद क्या होगा कुछ नहीं
I apologize, Lordship.
You are appearing? Yes.
Your Lordship, I believe today the injunction application is appearing with your Lordship. Lordship will remember this is the suit where our claim was made for money which was protected by a letter of credit. We had traded with some companies.
21.
19. It is. We traded with
the pro forma respondent number 4. HDFC Bank.
We had conducted some business with some traders in Bangladesh, and then the amount was secured by letter of credit by a few banks.
Defendant number 4. Which matter?
Number 5, Your Lordship. Performer.
Item number?
19.
19.
Viraj though.
Item number 19. CS 10.
Oh, I apologize. I was told it was item number 9.
You're the only one defendant. None appears on behalf of either of the parties. No accommodation is sought for. Let the matter place in the list of let the matter appear in the warning list. Next.
Number 20.
And I appear for the plaintiff respondent, Malik.
Yes.
Now, there is an application made by the defendant for under Order 9, Rule 13, Malik. The decree has been passed.
Decree.
Yes, Malik.
Yes.
And the only ground they have made out, Malik, that
who is appearing to the defendant?
And Mr. Shotodip Bhattacharya was appearing, Malik, as the counsel, Malik. I don't. There's one Mr. Snehashish De, who's the advocate in record, Malik.
Affidavits completed?
Yes, yes, Malik.
Ex parte judgment degree 29th April.
And here, Malik, substitute service was also done. Service was also made at the contractual address, Malik, last known contractual address, where it came back as unclaimed because the defendant had left the premises, but they had not mentioned any new address to us, Malik. So this is the situation, this is the factual background, Malik.
Nobody's appearing, what can be done?
Malik, I'll have to leave it on your lordship, Malik. Malik, your lordship is not dismissing, I find. So Malik, what can I do?
You have not filed the execution?
Not yet. Not yet, my lord, because your lordship, my lord, some assurance was given, my lord, though not recorded, my lord. My lord will kindly, my lord, I think there is someone rushing in, my lord.
For the applicant.
Yes, my lord.
The only thing is I'm led by Mr. Bhattacharya, Shoti Bhattacharya. I'm seeking just an adjournment for the day.
So suffering for the plaintiff, so suffering for the defendant. As per the prayer made by the counsel for the defendant, the case is adjourned.
For the applicant defendant.
Let the matter appear tomorrow. Next.
Grateful.
I apologize, Your Lordship. I believe the item was appearing as 19 yesterday. I believe the item I was appearing was as this was appearing as item number 19.
This
yesterday.
one?
This one was appearing
Yes.
as 19 yesterday. Your Lordship will remember.
You are appearing for the plaintiff.
You are appearing for the plaintiff, the petitioner.
Interim order granted already going to sir. Then
Your Lordship will remember the two plaints had come up before Your Lordship, where 6 defects were defected in each plaint. Your Lordship, in statement of truth, we had sought leave to correct that. Lordship has given us 6 weeks, so we are proceeding with that. On the other hand, the National Bank was appearing in the other suit, 680. Your Lordship will remember this 667. They had appeared in the other suit. They were to file wakalatnama in the said suit as well. The lady, I believe, my learned friend, is not appearing today. But I believe they had shown intention to appear in this suit as well.
Nobody is appearing.
They, on the last day, they had said, or rather, apprised Your Lordship that they would be filing their wakalatnama in this suit as well.
Counsel for the defendant number 2 submitters is appearing for the defendant number 1. She request 8 weeks time to file wakalatnama.
Yes. She had
As
sought
well
an
as
extension
affidavit
for
of
the same
competency.
in the other suit as well.
Okay, so what has happened? Whether she
Lordship,
filed
I
a
appear for HDFC Bank Limited.
Ah.
Pro forma respondent number 5.
Ah.
Lordship, no relief as such has been paid against us.
Only you appear and raise bill.
There are negotiating bank.
With the copies of the plaint.
That's why you receive the copy. You appear only you make submission. I appearing for the DFC. I will record that and send
File
the.
our wakalatnama.
There are negotiating bank. We cannot have any relief against.
I just received a request. I am appearing for the defendant number 2. I am only seeking leave to file my wakalatnama.
That's why 8 weeks time was granted on 24 January.
Your Lordship, that was in the suit 680. Your Lordship has to grant that leave here as well.
No, 667.
May I?
The extension has been taken in that, so that has to be also
667.
So, Lordship, I am appearing for a Bangladeshi bank. That is why it will take some time. I am seeking my request on 3 weeks time will require.
Sir, January 4 weeks time was 8 weeks time.
I bow down to your Lordship. That is the request. I have been asked to stand in for a while.
Yes.
3 weeks time.
We have no.
What about the other defendants?
We have served on all of them. Your Lordship will find the affidavits of service are already on record.
3, 4.
We have.
What about the suit?
The suit, Your Lordship, the plaint, as I indicated, as soon as it clears scrutiny, the summons will also go.
For the plaintiff, suffering for the defendant number 2 and suffering for the defendant number 5. You will file wakalatnama?
Yes,
Your Lordship,
for the defendant.
I'll also file wakalatnama.
On behalf of?
I'm on behalf of the National Bank. Defendant number 2, Your Lordship.
So it will create interest 18% from today till the filing of.
Your
When you
Lordship,
file the wakalatnama, you calculate the interest amount.
I apologize, Your Lordship.
That will bank.
The
Bank is not giving any amount without interest.
Your Lordship,
Or you give the undertaking that you will not create any interest to any of the borrower, then the court will.
Your Lordship, the whole issue is this is a bank based in
The
Bangladesh.
bank is not going without interest. So let the court put the interest.
Already, I am told that there is already an order in favor of the plaintiff which is subsisting.
We are seeking for
Suffering for the
extension of the
plaintiff,
same.
suffering for the defendant number 2 and suffering for the defendant number 5. Performer defendant number 5. So the counsel for the plaintiff, counsel for the defendant number 2 prays for time to file wakalatnama on behalf of prays for 3 weeks time to file wakalatnama on behalf of the defendant number 2. And counsel for the defendant performer defendant number 5 prays for time to file wakalatnama within 2 weeks. Consider the submission made by the counsel for the respective counsel for the defendants. The defendants are directed, defendant number 2 and defendant number 5. Counsel for the defendant number 2 and the counsel for the defendant number 5 are directed to file their wakalatnama within 3 weeks from date. List the matter.
Lordship, if I may make one prayer. The interim order is expiring on the 8th of April, Your Lordship. If that may be
Please
extended.
the matter
Since Your
on-
Lordship is giving 3 weeks.
Please the
for
matter
by
on
Wakalat
5th of March 2025. May. 5th of May 2025. Full stop. The counsel for the plaintiff submit the interim order granted earlier is going to be expired on 8th of April 2025 according to place for extension of interim order. In view of the submission made by the counsel for the plaintiff, interim order is extended till 8th of May, 5th of May, na? Or until further order, whichever is there. Next.
Grateful.
You do, my lord, I am for the plaintiff, my lord.
I am here for the defendant, my lord. This is my application for rejection of the plaint that suit does not disclose any commercial dispute. What has happened, my lord? I'll just give the brief and then I'll proceed with the plaint. My lord.
Ready?
Yes, my lord. My lord, the allegation in the plaint is simpliciter that goods sold and delivered, and that the defendants had not paid some part of the money, and for that suit was instituted. Now, before that, my lord, instituting the suit, they went up in before the NCLT, for NCLT Kolkata against the defendants. Now, before NCLT Kolkata, there was a settlement agreement executed by the parties, that is their allegation, and in terms thereof, certain monies have already been paid. They say that a balance of 50 lakhs and odd, for which they have, that was dismissed. The NCLT proceeding was dismissed. Thereafter, they filed a suit. Their cause of action is, instead of the invoices or the goods sold and delivered, is the settlement agreement. That is the reason why I filed this application, because it does not constitute or does not qualify the definition of a commercial dispute. That is all. Now, I'll just place, I'll just will be relying on only one judgment, Ambalal Sarabhai, that the interpretation there has to be strict interpretation. I'll just rely on it later. I'll just point out, it is the pleadings in the plaint from which the cause of action has to be ascertained, and that has to be seen to judge whether the disputes as canvassed in the plaint falls within the definition of a commercial dispute or not. For that purpose, Lordship will kindly once take the plaint. Which is, it starts from page 4. I'll be placing. I'll just say this, 2, 3, 4, and 5 is the background of the disputes.
Yes.
The pleadings start at page 9 onwards. That 2, 3, 4, and 5, they say they had sold as goods. I'm not relying on that. Lordship will then thereafter straight away take paragraph 13 onwards.
Of the plaint?
Yes, plaint. This is at page 12 of the application, running page 12 of the application. Para 13, during the pendency of the aforesaid application, that is the NCLT application, the defendants from time to time paid the second installment to seventh installment in terms of the aforesaid settlement agreement, amounting to rupees 2 crores 65 lakhs and odd in the following manner. In view of the aforesaid payment made by the defendants, para 14, wide order dated so and so, your plaintiff withdrew the said restoration application from this honorable tribunal, should be from the honorable tribunal, as the defendant was honoring the settlement agreement dated 1st March 2022, and only the 8th installment remained due on the part of the defendant. So this entirely is with regard to the settlement agreement. Copy of the said order is annexed, para 15, but unfortunately, after the aforesaid withdrawal of the plaintiff, the defendant again failed and neglected to honor the terms of the aforesaid settlement agreement dated 1st March 2022 by not paying the English 8th installment of rupees 44 lakhs 28,000 and odd, only within 2nd October 2022 as referred in the aforesaid settlement agreement. Several requests for repayment of the 8th installment were made by the plaintiff to the defendant through mail, and copies of the same are annexed here too. Thereafter, Lordship will kindly take para 22. This is a page, running page 15 of the application. Pursuant to the aforesaid, the plaintiff immediately filed a restoration application. There was some default
they say in the previous paragraphs, for revival of the main company petition being so and so before the Honorable and National Company Law Tribunal, Kolkata, but the same was rejected on 2nd June 2023 with liberty to the plaintiff to avail remedies available in law to claim the outstanding dues. Para 23. Thus, there remains
44 lakhs.
a balance of amount of 44 lakhs only, which has to be paid by the defendant upon the petitioner according to the settlement agreement. They are not claiming their cause of action is not the invoices, but the settlement agreement. Let para 24, further in clause 2 of the aforesaid settlement agreement, it has been stated that in case Simplex commits any delay in making the aforesaid agreed installments thereof, then Simplex shall also be liable to pay an additional interest at the rate 12% per annum 25. Pursuant to the aforesaid, the defendant is liable to pay an additional sum of rupees so and so. Then again, Millard, the last line, para 25, thus there remains a balance of rupees 49 lakhs only, which has to be paid by the defendant upon this plaintiff according to the aforesaid settlement agreement. 26, that the cause of action of the present dispute arose on 2nd June 2023. The invoices are not of 23, much before, when the NCLT Kolkata gave liberty to the plaintiff to avail other remedies available in law to recover the outstanding dues from the defendant and both the officers. Lord, that is all from the plain. Lordship will thereafter kindly take the agreement once, which is appearing at para page 21, running page 21 of the application.
Yes.
Now, my Lordship will kindly take para page 23. It's internal page 2 of the agreement.
Yes.
And I'm just placing paragraph 1. The parties thereby expressly agree, acknowledge that in view of the settlement arrived between the parties, Simplex shall pay a sum of rupees 3 crores 44 lakhs and odd, along with an additional sum of rupees 15 lakhs on account of interest and delayed payment, and further thereafter the settlement amount thereof hereinafter referred to as the settlement amount towards full and final settlement of the dues of MRC. Thereafter, para 3, MRC expressly acknowledges and agrees that the settlement amount represents full satisfaction of anything and everything that MRC claims or could claim that Simplex owes to MRC. And by signing this agreement and accepting the consideration provided herein, MRC is willfully giving up forever any right to seek any additional payment, benefit, compensation, damage, or relief for anything arising from or related to the purchase orders between MRC or any and Simplex or any of their past, present agents, representatives, or employees. Similar next paragraph, next page, paragraph 6 only. Except as otherwise agreed, herein the agreement supersedes all prior discussions and agreements, whether oral or written, including all correspondences, if any, between the parties with respect to the subject matter of this agreement. So now, Millard, once they reach this settlement agreement, now, Millard, even according to the plain pillar, their cause of action is not the purchase order. I could have understood, Millard, they have given a go-by to this purchase order, this settlement agreement, and their cause of action was the original invoices. It is not. Their cause of action arises out of a settlement agreement. Now, Millard, under 2C, Millard, there is no, Millard, none of the Millard definitions, disputes, Millard, as provided under 2C, Millard, of the Commercial Codes Act.
Yes.
I'm sorry. This para 2, section 2C defines commercial disputes. Although yes, in any case, dispute as to agreements for sale of goods and provisions of service, which is 18, so Roman 18 is there, but this would have been, if it would have come under this definition, if they had sued under the purchase orders or the invoices. Lord, that is my short case, my lord, and I'll just rely on one judgment. Lord, I hand over a copy, my lord.
Which paragraph?
Yes, my lord. Lord, Lordship will kindly take, my lord, as far as pleading is concerned, I'm placing paragraph, Lord, 8. Before that, my lord, it was HON'BLE Saravai, my lord, essentially was a, but with regard to immovable properties, my lord, used for trade or business or trade, my lord, that is not here. But whether to ascertain the
exclusively is
yes, strict interpretation, and Lord, para 8. Though such rival contentions are put forth by the learned senior advocate on either side, these aspects cannot be dealt with in abstract. Instead, the nature of the dispute and the jurisdiction to try the same is to be reflected in the suit itself. Since a civil suit, the pleadings, namely the averments in the plaint, would at the outset be relevant to confer jurisdiction.
37.
Yes, ma'am.
Come to 37. Paragraph 30.
And I would also place 31 and
yes, that is
very well.
given. Yes, sir. Yes. What is your contention? How it is the commercial?
The dispute between the parties arises out of paragraph 2, 3, and 4 that my learned friend has given a go by. But the plaint has to be read as a whole. Now the plaint says that there was a commercial relation between the parties.
That was there. You initiated an NCLT. NCLT settlement was agreed.
Settlement was arrived by them. And
Agreement.
now can they back out of the settlement agreement? Settlement agreement arises out of a commercial dispute.
Maybe.
But
Now
the settlement agreement, when the settlement agreement arises out of a commercial dispute, the settlement agreement is itself in commercial nature.
But the amount which you are claiming in terms of the settlement agreement, this is the business transaction under the commercial. Show me which clause. Which clause of the 2C?
But I cannot rely on the 2C because 2C does not say about any settlement agreement. But if the
commercial disputes 2C, the total definition, show me which clause you are coming
but
under
if in a
this.
commercial suit somebody agrees about a settlement agreement, then a settlement agreement is arrived. Then if the settlement agreement is failed, then whether he will go to the commercial division and go to the non-commercial division.
Non-commercial. Because you have leave aside the total commercial after I enter into the settlement agreement.
The settlement agreement speaks about the commercial nature of the disputes. The dispute was raised regarding the commercial nature of the business
that was settled. That was settled.
Yes.
The commercial dispute which were raised before the NCLT, that was settled.
Anyhow, my lord, if my lord pleases, then transfer it to the non-commercial. I'll take all the legal procedures. I'll not stand in the way.
No, that I am not
if my lord is of the
pressing
view
upon you. I am telling satisfy this court.
If my lord is of the view that it should be go to the commercial.
Prima facie, what the defendant has raised before this court, prima facie it was found it is not a commercial dispute.
If it's not a commercial in
If
the
you can satisfy this court, no, it is a commercial dispute.
This matter is already been pending since 2023. I do not want to drag the matter anymore. If it is not a commercial in view of the my lord, it's sent to the non-commercial matter and let my GA1, that is a judgment upon it.
It cannot be sent. Commercial to non-commercial, it cannot be sent. It has to be returned, then you have to file the suit. Commercial, that case cannot be transferred. The
then I shall bring some judgment that it can be done, my lord.
No.
It can be done. It has
My
to be done.
judgment is there. I have held. It was the similar with the consent of the parties. I have transferred. Subsequent review application was filed, and the review application I have dealt. No, from section 15 is not applicable for transfer from the commercial to non-commercial. Non-commercial to commercial, it can be transferred under 15. Now it is you have to withdraw.
Then my lord would kindly give me some time to deal with the judgments. I shall bring judgments.
Come with the judgment. If the court is powered to transfer from the non-commercial to commercial.
And not regarding that, and also that whether the settlement agreement which arises out of a commercial transaction.
That's show me which clause.
I will bring the judge.
Show me which clause it is coming.
In 2C1, my lord.
2C1. That is the only. Which
I am
clause you are coming?
it can be a mercantile document also, because this gives the rise of the transaction that I will be liable to be paid from the settlement agreement.
Okay, come on.
I shall bring with the judgments. Give me a
May I only file the affidavit in reply, my lord? It was not filed.
Suffering for the plaintiff, suffering for the defendant. Full stop. The plaintiff has filed, the defendant has filed an application being GA4 of 2024 for rejection of plaint.
Yes,
For-
my lord.
For rejection of plaint. For rejection of the plaint. Counsel for the defendant has concluded his argument. Full stop. Counsel for the plaintiff prays for time. According case is adjourned. The counsel for the defendant has filed affidavit of service. Let the same be kept. Affidavit in reply.
Reply.
Affidavit in reply. Let the same be kept in the record. This is the matter on when
8th
8th May.
No, my lord, 8th April.
10th April.
10th. Deeply appreciated.
Deeply appreciated.
Lordship, item number 22, I am appearing on
I am
behalf
the
of the
plaintiff.
defendant. I am led by Mr. Shomaba Ghosh. My lord, he has some personal difficulty not come to the court, your lordship. I'm praying for not today. May it appear on Monday, your lordship.
What
May-
is
May I
the
just say,
matter?
my lord, this is my application is a money suit. In the money suit, my lord, I had filed GA1, which is for attachment before judgment. Your lordship has been pleased to grant me ad interim order. That has gone to the appellate court. My lord, the honorable division bench has modified the order to some extent, send it back to your lordship. So, my lord, GA1 pleadings are complete for final disposal. That is the plaintiff's interlocutory application. Now, the defendant, my learned friend's client,
Also filed a 30
yes, they have also filed, my lord, a written statement and counterclaim. My lord, in aid of the counterclaim, they have also filed an application for attachment before judgment. They also have a monetary claim against
Your
me.
lordship.
So that is before your lordship. I am praying for direction for affidavits in that matter. My lord, that is GA2.
And counterclaim file the affidavit and this additional written statement.
My lord, I have mentioned the matter before your lordship yesterday. Your lordship has given me leave because I am beyond 30 days. So your lordship is
Within 120.
yes, lordship has given me the leave yesterday.
So you want to file affidavit in opposition in connection with
GA2, my lord.
GA2.
Yes.
So appearing for the plaintiff, so appearing for the defendant. Full stop. So counsel for the plaintiff prays for time to file affidavit in opposition in connection with GA2 of 2020. 2025.
Yes.
Let affidavit in opposition be filed within 2 weeks. Reply.
My lord, 3 weeks because the
3
April
weeks.
break will intervene. I
3
will be in
weeks.
difficulty.
Reply, if any, there to be filed within 2 weeks thereafter.
Fix your lordship.
This is the matter. 2 weeks, 5 weeks, na? This is the matter on 11th May.
Extremely great.
11th is holiday. 14th May.
Is most grateful.
And let's reply deduction for 2 years, 2 weeks, your lordship.
Lord, I appear for the plaintiff in this matter, my lord.
Yes.
Lordship recollects my learned senior
Section
friend.
8.
Section 8, my lord. But subsequent to the last hearing, my lord, we have received this letter from the client, my lord.
For?
She wishes to withdraw the suit, my lord.
Withdraw the suit?
She is unable to continue with the litigation costs and the losses that she is incurring.
That can't be the reason. There must be other reasons, which my lord. In fact, I was sitting with him for last half an hour. He didn't inform me that this has been received.
And that's recorded in the letter, my lord.
My lord, 5 and 8 may be allowed.
Huh?
I'm
5 and
withdrawing
8
the
may
suit,
be
my
allowed.
lord.
Because already proceedings have been initiated, arbitration proceedings. But
yes,
my lord. Now I have to make only this submission, my lord, that she wishes to withdraw the suit. And if the suit is withdrawn, my lord, automatically both the GAs, my learned friend's GA and my GA also goes for a toss, my lord.
What is your GA? GA1?
GA1.
And other GA is?
GA2.
GA2 is my GA 5 and 8.
Section
My
8.
lord allows withdrawal then if he
Hello?
allows his withdrawal then.
Senses and suffering for the plaintiff, senses and suffering for the defendant. Full stop. Counsel for the plaintiff has handed over a communication dated 28th of March 2025 sent by the plaintiff to the advocate on record of the defendant
the plaintiff.
Wherein it was informed by the plaintiff that the plaintiff has decided not to continue the business of selling survey item from store number 57767 any further and to discontinue the instant legal proceeding and requested the learned advocate to withdraw the suit. On the basis of the communication dated 28th of March 2025, counsel for the plaintiff prays for withdrawal of the suit. This full stop. Considering the submission made by the counsel for the plaintiff and peruse the communication dated 28th March 2025, CS Com 710 of 2024 is dismissed as withdrawn. Full stop. Consequently, connected applications being GA Com 1 of 2024 and GA Com 2 of 2024 are also dismissed.
My lord will, with regard to GA2, my lord will kindly put some lines with regard to GA2, saying that because dismissal of that as such will because already arbitration proceedings have been initiated. We have said that we have initiated arbitration proceedings. Therefore,
Counsel for the defendant submit that the defendant has filed an application being GA2 of 2024 under section 5 and 8 of the Arbitration and Cancellation Act for referring the matter to the arbitration, and he prays for keeping the set open to the defendant to raise the to take appropriate step before the appropriate forum
and continue with the arbitration.
In that regard, may I just make one humble submission? Lord, that liberty he always has.
That's why now tomorrow you will say he has not taken the leave. So he will
Lord, now there is no suit, my lord.
That's why no suit, but I am dismissing their application. So dismissing the application, that means that is also dismissed.
Yes.
You are withdrawing.
Lord, if your lordship reads the
correct,
last
did not want to continue. I recorded that.
Third last line, my lord.
I recorded that.
Accordingly, I have decided not to continue.
Correct. Continue the business selling of survey.
So now there will not be no dismissal.
And
that doesn't mean the
matter is,
arbitration.
if any occasion arise with regard to the appointment of arbitrator.
I'm grateful, madam.
The communication be kept in the record. Yes.
Number 25.
Lordship, I appear for the plaintiff. Lordship, the handling advocate has had a medical emergency. I'm praying for not today, Lordship.
You are appearing for?
The plaintiff, Lordship.
As per the prayer made by the counsel for the plaintiff, case is adjourned. Let the matter appear on 17th April.
Highly obliged.
Next.
My application, my lord, I pay for the defendant, my lord. I taken out an application, my lord, for dismissal of the plaint because, my lord, leave under clause 12 has not been sought for in this, my lord. A plain reading, my lord, of the plaint would show that a substantial portion of cause of action had arisen outside the jurisdiction of this honorable court, and part of it was within. However, my lord, I don't see, my lord, any leave being prayed for or granted, my lord. My lord, may I indicate, my lord?
GA 2.
GA 4, my lord.
GA 4.
Here the GA 4. Readings completed.
But it's appearing for the first time, my lord.
No.
GA 4. No, I'm so sorry, my lord. Stand corrected, my lord. So I stand corrected.
GA4.
अरे उधर हमारे application है. This application. But my application perhaps is appearing for the first time today.
Your application is J4, no?
My lord, I think,
Rejected.
my lord, on the last occasion, direction was given for filing affidavit, my lord. My,
J4 का order नहीं है?
Oh,
Order तो है?
it is, my lord, it is.
my lord,
Order of
it is an
28th
order
February.
of 28th February. Kindly come to the second page.
Yes, yes.
The plaintiff has filed an interlocutory application or applications being GA Form 2 and GA Form 3. Defendants have filed the application being GA4. Then, my lord, next paragraph, all the applications are to be taken up together.
Put up all the
Then next-
application in view of the above parties are directed to exchange their affidavit within
Yes,
3 weeks.
Yes, my lord.
Let the matter appear on 28 under the heading.
Now, we have given our affidavit in opposition to, my lord, the Order 7 Rule 11 application long back.
Yes.
There is no reply there too.
You not find the reply.
My lord, my lord,
I don't rely on that. It has been served, but kindly take up, my lord, Order 7 Rule 11 application that they have to proceed. I have to proceed on the basis of the plaint.
my lord, I have, although I have not, my lord, had the opposition, my lord, but I'm sure Mr. Mitra has, my lord, served upon my advocate and record, my lord. Yeah, ठीक है, I am not disputing that. I am saying I have not been given, my lord. And since, my lord, it is proceeded on the basis of the plaint, my lord, I am ready to place my application.
It has been served, my lord.
ठीक है, I'm sure. My lord, kindly takes, my lord, paragraph.
24th of March.
My lord, kindly, my lord, takes page 7, paragraph 5 of my application, where, my lord, I have indicated, my lord, my grounds, my lord. Really, in the nature of demurrer, my lord, opposition is really not required, my lord. Kindly, my lord, takes, my lord. This is a case, my lord, simpliciter, my lord, money lent and advanced and not paid. That is the case, my lord. My lord, if my lord takes paragraph 5, my lord, I say, my lord, that the following averments transpiring from the plaint and the documents annexed thereto demonstrate that a significant part of cause of action of the instant suit had arisen outside the jurisdiction of this honorable court. Now, how do I say this, my lord? Kindly takes, my lord, paragraph A. As per the cause title in the plaint, the petitioner number 1 herein has its registered office, and the petitioner number 2 and 3 work for gain from out of the premises number 263B AJC Bose Road, 6th floor, Kolkata, 20, outside. Now, my lord, kindly takes the plaint at page 17, my lord, of my application, simultaneously, my lord.
Yes.
My lord, will find the cause title at page number 17. My lord, sees, my lord, Amit Vanij Private Limited is the first defendant, and my lord, the plaint states that it carries on business 2 addresses, my lord.
AJC Bose.
AJC Bose Road,
Outside
6th floor. This is admittedly outside the jurisdiction, and the second office, my lord, is Siddha Park, 99 Park Street, within jurisdiction.
Correct.
Then, my lord, so, my lord, I say, my lord, I admittedly carry on my business from jurisdiction outside, also, admittedly. Now, my lord, the next, my lord, pleading, my lord, it appears.
So you are admitting with regard to the both address.
Yes, that's an admitted. But I am today proceeding on basis of the averments made in the plaint. I cannot go beyond that.
Yes.
So, well, it's a plaint's case, my lord, that I carry on business at 2 premises, one outside, one within. The plaintiff is within. That's immaterial. The defendants. Then, my lord, kindly takes 5B. That after the aforesaid post-dated checks, my lord, it is alleged, my lord, that checks were issued which were dishonored. After the aforesaid 5B.
Yes, 5B.
Our petition.
Page 7 of the
Yes, of my.
Sorry, sir.
After the aforesaid post-dated checks presented on October 31st, 2020, through the banker of the respondent, namely Karnataka Bank Limited, were dishonored, the learned advocate of the respondent issued 2 several demand notices dated 12th November 2020 and November 25, 2020 upon the petition number 1 herein at its registered office 236B, AJC Bose Road, outside the jurisdiction. Now, this, my lord, will find at page number 59, running page 59 and 62, where these letters, my lord, are annexed to the plaint. Well, kindly takes, my lord, page 59. My lord, will find Mr. Shantanu Roy, advocate, issues this demand notice, my lord, under section 138B of the Negotiable Instruments Act, my lord, to the 3 defendants and at all the addresses, my lord, as appearing in the cause title, including 236B AJC Bose Road, Kolkata, 6th floor. And similarly, my lord, number 2 and 3 is not relevant here, my lord. Part of cause of action, I would say, the defendant number 1 carries on business at 236B. And in any event, 2 and 3 are not really, cannot be made parties because they are not a guarantor. They are made defendants because they happen to be directors of the plaintiff. That's a different aspect of the matter. I'm not pressing on that aspect today. So, the demand notice at page 59, dated 12th November 2020, is issued at 236B. Admittedly, calling upon me to make payment of the sum covered by the dishonored check, my lord. Then, my lord, kindly, similar notice is at page 62. This is another demand notice of Mr. Niloy Sengupta, advocate, my lord, dated 25th November 2020.
Yes.
And again, 236B.
Yes.
Along with 99-day Park Street. And then, my lord, it is kindly comes to page 7 again to my application, my lord, because all my points are, my lord, noted in paragraph 5. My lord. Kindly comes to paragraph 5C now, my lord, again. It transpires from the pleading at paragraph 9 to 13 and 20 of the plaint that the present suit has been instituted on basis of citus of the cause of action, that is dishonor of the aforesaid post-dated checks, and the demand notice dated November 12, 2020 issued and served upon the petition number 1 at its registered office at 236B. Now D, the prior to institution of the instant suit, under a cover of letter dated 22nd March 2023, learned advocate for the respondent had served ballot at its registered office 236B AJC Bose Road outside a copy of the application filed before the mediation center, my lord. This application, my lord, will find at page 81, running page 81, which is again an annexure to the plaint, my lord.
Yes.
The letter of 22nd March 2023, all the defendants were addressed at 236B AJC Bose Road.
Correct.
And also 99-day Park Street. The millet kindly comes back to paragraph page 8 of my petition. Then millet, a notice dated September 12, 2023, September 21, 2023, and October 3, it should be October 3, millet, issued by the Mediation Center. Millet. Now, Mediation Center also issues me notices, millet. These appear at page 77, 78, and 79, calling upon me to participate in the mediation process, millet.
Yes.
My lord will kindly take page 77 to 79, where, my lord, towards the bottom of page 77,
yes,
let this address appears 236B AJC Bose Road along with 99A Park Street. So, my lord, I was notified at outside jurisdiction as well.
Both addresses.
Both the addresses.
Yes.
This, my lord, would also appear at 78, again on 79.
Yes.
And also at 80. Then we'll kindly takes page 92 and 93.
And this notice has been sent through mail.
This was sent, my lord,
through mail.
To mail at my office at outside jurisdiction.
Okay.
Then, my lord, kindly takes page 92 and 93 also. Where, my lord, page 92, I write, my lord, to the mediation secretary, member secretary, my lord, for adjournment from my office outside jurisdiction, page 92.
92?
Yes, my lord.
26 AJC Bose.
And then, my lord, kindly takes page 93, where this application filed by the plaintiff before the mediation center, my lord, this application also, my lord will see item number 4 at page 93, the address and contact of details of the applicant should be opposite party, my lord, to 236B AJC Bose Road.
Both addresses there. Yes, next.
Now, my lord, apropos this, my lord, kindly takes, my lord, an averment in the plaint with regard to cause of action. Page, paragraph 20 of the plaint, my lord, kindly takes.
Para 20.
Yes, my lord, at running page 27.
Yes.
May I place this paragraph, my lord? The cause of action of the instant suit has arisen out on several dates, including 31st October 20, 3rd November 20, when the plaintiff presented the checks, both dated 1st October 2020 on RBL Bank, as pleaded in paragraph 8, with an expectation of encashment of the same, as per the assurance of the defendants, and also respectively on 2nd November and 5th November, when the said checks were reported to be dishonored and returned by the concerned bank with remarks funds insufficient from its office, Park Street branch within jurisdiction, and on 12th November, when the plaintiff caused demand notice to be issued upon the defendants, and in reply thereof received the letter of 28th November from the defendants through their advocate, where the defendants through their advocates have replied to the demand notice of the plaintiff, wherein they had duly acknowledged and admitted the claim of the plaintiff, however denied to make payment thereof. And lastly, on 31st January 21, when the defendant further made part payment of interest in acknowledgement of the principal amount, it is well settled that in computation of the period of limitation under any general law and special law, the exclusion. So then Supreme Court's exclusion is, so we'll see the cause of action, for this commercial suit, was that money lent in advance, checks issued, dishonored, demand notices issued, within and outside, received outside and within, not made payment, mediation center approached, mediation center caused service of the notice to appear within and outside. So,
no, but there are 20 in the middle. The check was dishonored from the Marquis.
Yes, part outside, part within, part and demand raised. Kindly reads, cause demand of notice of demand to be issued upon the defendant.
Check dishonored.
No, not only dishonor, my lord. The demand is also issued. That's the foundation of the case. There are several bundle of facts which, my lord, constituted the cause of action.
Correct.
One of those, which I say, my lord, is that a demand was issued and delivered to the defendants at its office outside the jurisdiction. That's the case made out. It is also evident from the documents.
Correct.
So, my lord, failure to make payment despite receipt of demand notice served outside the jurisdiction. Further, the defendant carries on business, admittedly, outside as well. So, my lord, repeated attempts to serve the defendants at its offices outside jurisdiction. In my respectful submission, therefore, my lord, it can be concluded on the face of the averments made on the plaint that a part of cause of action has in fact arisen outside the jurisdiction, my lord. And, my lord, I need not rely on the settlement, just for the sake of, my lord, completeness, I'll cite Chenrup Sampatram, which is a full bench judgment of this honorable court, my lord, and I'll rely on one paragraph of this judgment, my lord, which is reported in, my lord, 2009 1 CHN 346. It's a full bench judgment, my lord. May I place paragraph 24 of the judgment? Am I right? Page 346, 2009 1 CHN 346.
Yes.
I'm sorry, my lord, I'm holding my lord beyond, my lord. I'll just conclude, my lord, 2 minutes, my lord. It kindly takes, my lord, paragraph number 24. There are 3 limbs to clause 12 of the letters patent. The first limb covers suit for land or other immovable property which is not germane for the present purpose. The second limb speaks of place of accrual of cause of action in the suit, requiring no previous leave if the cause of action arises wholly within the jurisdiction, but requiring previous leave if only a part, however infinitesimal or significant, of cause of action arises within jurisdiction. And the third is the situs of the defendant at the time of commencement of the suit. A suit for land, well, I was relying on this portion where an infinitesimal, even if an infinitesimal part of cause of action arises outside jurisdiction, leave to institute before institution has to be prayed for and granted, my lord. In this case, not done, my lord. May I read on, my lord? A suit for land or other immovable property stands on a different pedestal, and it is unnecessary to go into that aspect of clause 12 here. But in a suit which is not a suit for land or other immovable property, the plaintiff has a choice of invoking the jurisdiction of this court either on the two remaining limbs of clause 12. If there is a solitary defendant in a suit which is not a suit for land or immovable property, the plaintiff may unquestionably institute it on the original side of this court if the entirety of cause of action arises within the original jurisdiction of the court, and irrespective of where the defendant may dwell or carry on business or personally work for gain. If there is a solitary defendant in a suit which is not a suit for land or other immovable property, the plaintiff may institute it on the original side of this court if a part of cause of action arises within the original jurisdiction of this court, irrespective of whether the defendant may dwell or carry on business or personally work for gain, subject, however, to obtaining prior leave under clause 12 to institute this suit.
Yes.
This is, I rely, and therefore, I say, admittedly, there is no leave sought for. The plain has to be rejected. Those are my submissions on GA 4. My friend instructs she has not received any opposition, although it appears to be sent on mail, which but that's not relevant. It's not relevant.
So appearing for the plaintiff, so appearing for the defendant. Defendant has filed an application being GA Com 4 of 2025, praying for rejection of plaint. Police of counsel for the defendant has concluded his argument. And due to paucity of time, counsel for the plaintiff could not argue the matter. Accordingly, case is adjourned. Let the matter appear when?
Any day convenient to your lordship, my lord. If a time is fixed, I will not take long. My lord, your lordship, my lord, has seen everything. And that is exactly why, my lord, I say that if a close date is given, my lord, so that I don't forget. I tend to forget things now.
8th April. Under the heading adjourn motion at the top. 8.
At, well, at the top.
8. I'm in some difficulty on 8.
9.
It is whole day arbitration these 2 days, my lord.
Then 11.
Yes, 11 is
11.
Tickets.
Deeply obvious.
Yes.
Mr. Ghosh's matter, I think, is going to take some time. And there is also a matter fixed at 3. And there's a 3:30 resolution today. My lord, my item number 6, it's a contempt. It won't.
Item number 6 of
my lord, non-commercial list. The contempt, it won't take more than 2 minutes. If your lordship gives us 5 minutes before your lordship rises, my lord, we can come back at 3:20 and break. Break.
कॉल कर हम बोल देंगे
Item number 1.
that
My
application is allowed.
Developed.
So it is dismissed, but I have made it clear that this court has only not gone into the merit, only with regard to the maintainability and the jurisdiction this court has decided, and you are liberty to file it back before the appropriate.
May it please go. We have a small gift for my lord. Now I've discovered that in our note it said serial number 1213. Well, my learned friends had given us a compilation. I don't know if your lordship has it. The defendants had also given. So it is those numbers. When I deal with it. So that was my confusion also yesterday. It's in the note. I'm not corrected note before. It'll be too much confusion. Your lordship has already, I'm sure, made some notes. So I'm not giving a corrected note. If required, right at the end, I'll give.
Yeah.
Now, I had placed my entire argument yesterday, but I had not shown any of the decisions. So today I will attempt, my lord, to run through all the decisions. So at the outset, general, if I may use the term, it shouldn't, but it's a lecture on defamation. 2016, 7 SCC 221, that's serial number 7 at page 98 of the compilation, my lords, of the first volume. This was the case. The relevant part, my lord, the judgment begins after the head note at page 125 of the compilation. 125. But before I place a few paragraphs of the judgment, the challenge in this judgment was to the constitutional validity of section 499 of the IPC, whether criminal defamation should remain the law or not. And this discussion, it's a very broad discussion, Malad, that what was the tension between the freedom of speech and the right of this. And then, of course, the Supreme Court has gone in from the beginning of time why reputation is important and why this law of defamation is a very important part. It's a fundamental right, as it were, even though it is a fetter on the freedom of speech. So the most difficult part of the decision, my lord, is the first 10 lines. If I may place it, your lordship will see why I'm saying that. Page 125 of the compilation. Compilation. Okay,
yes.
The batch of writ petitions preferred under Article 32 of the Constitution of India exposits cavil in its quintessential conceptuality and percipient discord between venerated and exalted right of freedom of speech and the expression of an individual, exploring manifold and multi-layered, limitless, unbounded and unfettered spectrums, and the controls and restrictions, constrictions under the assumed power of reasonableness ingrained in the statutory provisions relating to criminal law to, should be revive and uphold one's reputation. And simply it's saying that the freedom of speech has reasonable fetters, and how far should this fetter go? I just wanted to place this for academic reasons, my lord, and it's a real tongue twister. Then, my lord, paragraph 2,
This is simply the third line. In the batch of writ petitions, we are required to dwell on the constitutional validity of section 499 and 500. So that is what they had to decide.
Yes.
Then in paragraph 6, they have set out 499. And as it fell from my lord, the exceptions are set out on the next page, at page 127. Now, these exceptions, of course, are related to criminal defamation, and they can also be taken, I presume, in civil defamation. But this judgment says right at the end, I'll show that these have to be proved by the person asserting the exception. So that is the principle that this case will help me. Besides, of course, the history of defamation law. So these were the exceptions. I'll just read the first and second one, Malad, which they have tried to make out. Imputation of truth which public good requires to be made and published. It is not defamation to impute anything which is true concerning any person, if it be for the public good, and the imputation should be made or published. Whether or not it is for the public good is a question of fact. Now, this they have to prove that it was for the public good. No evidence. And the second doesn't come in, public servants. Then, my lord, the merits of a case. So their defense is really that first exception. And my submission is they have not proved it. Now from paragraphs 9 to 21 are the submissions made by various counsel. And it's very educative, my lord, but I'm not placing it here because
I think ninth will also come. Ninth. In the good faith.
Yes.
In the good faith protection of his other person interests.
It is not defamation to make an imputation on the character of another, provided the imputation is made in good faith for the protection of the interest of the person making it. Or any other person, or for the public good.
Because their contention, which Mr. Bhattacharya has argued, because it is the correct, but you have acted illegally. That's why they wanted to bring to the public
notice. So there are two. There's a very subtle difference, my lord. What is the fact? If a defamation is per se defamation, which I have stressed on, the language which is making these broad allegations, if it is per se, the intention doesn't matter. Even if that person comes and apologizes and says, I didn't mean that. But if the word is defamatory per se, he has to pay damages. And if it is his opinion, he said, I didn't think this was a good thing to do. Then, my lord, then a fair comment defense is available. So that in these decisions, my lord, it's there that there's a difference between a defamation or in fact and in opinion. So that is, and the intention is irrelevant. It is if it is by fact. So this this really would not come in. But be that as it may, the defense have shown paragraph 9 of their written statement what they've said. They want to prove the truth, and they said that we don't show the truth without any evidence. So it was the onus was on them to show the evidence. Now, if my lord comes to the turns over the next page, paragraph 9 to 21 are the submissions of the parties. Well, I'm not really placing them because, and the amicus curiae. Then they are all to do with the balance of the freedom of speech, and if it's a reasonable fetter to still have the law of defamation under criminal law. But there is no doubt as far as this judgment is concerned that civil law of defamation is alive. And in fact, the petitioners claim that it should only be a civil. They didn't want to abolish defamation. They just said that it should not be criminal because it's liable to be misused by the authorities. So 9 to 21, I'm not placing. The paragraph 22, 148. This is completely academic. The definition, the meaning of the term defamation. So Salmond is quoted, then Halsbury, and the Chambers Dictionary. I'm not reading out the quotations, Manoj. Your Lordship is well aware what it is. Then there are at least 9 different quotations as to what defamation is. So it has to be, basically it has to be a false statement which is showing the other person in injuring his reputation, as it were. So the first definition is the best to take because that is the standard academic definition. Summoned, 23.1.
Yes.
A defamatory statement is one which has a tendency to injure the reputation of a person to whom it refers, which tends, that is to say, to lower him in the estimation of right-thinking members of society generally, and in particular to cause him to be regarded with feelings of hatred, contempt, ridicule, fear, dislike, etc. The statement is judged by the standard of an ordinary right-thinking person. So these are the definitions of. Now, what is important is it has to be.
Have you initiated the criminal proceeding? What has happened to that?
No, we have the CSC has not.
No.
One of the employees had, because his face was portrayed as with
What has
a
happened
picture of Bin
going
Laden.
on?
That I presume is going on. I don't know. That was done in 2004. It's in the evidence that he has done it, but the records we have not shown. Then the 23.2 is Halsbury's definition.
This all up till 23.9.
Only thing is that it can be the last line of the Halsbury definition, disparaging or injurious to him in his office, profession, calling, trade or business. That's because I'm a company, it will
That's
come.
why when I used to conduct the defamation criminals cases, so if the witness has to be bring, then the witness has to say, due to the publication made by the editor or publisher,
Yes.
my reputation was lowered down.
Yes.
And to corroborate that, 2-3 witness, yes, he was my good friend. I came to know from the paper publication, and after reading the paper publication, the estimation of my what my friend has lowered down.
It's very difficult.
That is the
worse is, I don't know if your lordship has had the occasion to have a final hearing for a trademark passing off matter. None of them come to the suit court. Eventually, it gets settled because they're all commercial. But then one had come before me and I said, you bring me the fool who was deceived. He has to go into the box and say that I was tricked and I didn't understand what was this thing. So it's very difficult to get a witness eventually.
Correct.
To get this. But fortunately, in this present case, my lord, since it's a company, I will show that the case law is consistent from the beginning that no special damages have to be proved if it is a defamation in the which is related to the business of the company. And here, mafiagiri, etc., is all to do with how I conduct and manage my business. Now, if I call a company a murderer, there are judgments which says that can't be because he cannot murder. A company by itself cannot
but
be
the
murder.
person in person.
So that's just an example, the subtle difference between a company and a person. But if it is in the way of his business, then definitely a company can sue. That is, I'll cite those judgments. I'm just running through this decision because this I wanted to show that it still exists because my learned friend took the point that civil law is no longer there. Now, all the discussions we'll find in this decision. So 23 was basically the definitions of defamation, and then is the from 25 is the concept of reputation. And it starts with the Bhagavad Gita, it quotes the Bible, the Holy Quran, etc. And of course, even Shakespeare at the end, which says that a good name in a man and woman is the immediate jewels to their soul. And he who robs me of that which does not enrich him and makes me poor. So that is the Shakespeare's thing. And then it says, another quote is there also at 27, take honor from me and my life is done. So, and then again, Socrates is also quoted saying that honor is a very important thing. And which is a fact, Mala, that people will, in a normal character, will not harm someone. But if it is a question of honor, they will give their lives also for honor. The people go to war, etc. So honor is even greater than life. And that is what these quotations are said. Then, then paragraph 31, the international covenants which recognize this. Just I'm reading one at paragraph 32.
Yes.
Article 19 of the International Covenant of Civil and Political Rights. Everyone shall have the right to hold opinions without interference. So this is a freedom of speech and etc. And then for the respect and rights and reputations of others. So you must respect other people's reputation. So you can swing your hand, but it should stop before it reaches my nose. So it's that much. That is the extent of our right of freedom of speech. Then, my lord, there are more discussions. Then there are further discussions, my lord, on what is the difference between character and reputation, etc. Not really relevant. Then all the courts, my lord, from the USA, South Africa, European Court of Human Rights are referred to. Now, my lord, will come to 59, which is really what I require. This really begins from here. To appreciate the said facets of submissions, it is necessary to appreciate that the ambit and purport of the word defamation. To elaborate whether the word defamation includes civil and criminal defamation. Only after we answer that question, we shall proceed to advert to the aspect of reasonable restriction of the right of freedom of speech and expression as engrafted in Article 19 of our Constitution. Then, Mala, the submissions of the Constituent Assembly debates are discussed. Now, my lord, will come to paragraph 67. Or rather, my lord, 66. 66. This is.
Yes.
This is to counter my learned friend's argument that is no longer there.
Para 66?
66, page 167.
Yes.
We have referred to the aforesaid aspect only to highlight the intention of the founding fathers and also how contextually the word defamation should be understood. At this stage, we state that in the course of hearing, an endeavor was made even to the extent that stating the word defamation may not even call for civil action in the absence of codified law. In this regard, we may usefully refer to Setalvad's Hamlin Lectures, The Common Law in India, where the first India's first Attorney General expressed that an important branch of law which remains uncodified in India is the law relating to civil wrongs. That's torts. Then if my lord comes down, then some of the most important rights of the person which the law protects from injury are rights to the security of his person, his domestic relations, and his property and reputation. So this was a recognized right from the beginning. Now, if my lord comes to 67, the common law of England was the prevalent law being adopted before the Constitution came into force, and it is declared as law in force under Article 372 of the Constitution by a larger bench's decision in Superintendent and Remembrancer of Legal Affairs versus Corporation of Calcutta. This is the 1967 Supreme Court. We have included that. So basically, the common law, what was there, becomes a part of our law. It is also thanks to this, all our acts, which are the Transfer of Property Act, Contract Act, that's why they are still prevalent. They have not been passed by our parliament. If you think about it, it's a very important aspect. And all the Privy Council judgments or all judgments before, they are a part of our common law. So it remains. But my learned friend's argument was that the law in England has now become codified, and therefore
so you cannot.
It is no longer common law in England, so it can't be common. Of course, that doesn't stand. So this 66 and 67 are important. Then 69. '68 is not. We have referred to this aspect only to clarify. Yeah.
प्रोटेक्शन है रखो लेने हैं कौन कर दिया डिस्पेंस रखो देखेंगे हाँ डिस्पेंस वहाँ कैसा गया कौन प्रेजेंट ठीक है देखेंगे अभी अभी है लिस्ट में। हाँ वो टाइम है, ठीक है देख लेंगे। आज का क्या प्रोडक्शन है? ठीक है लिस्ट कर दो, लिस्ट में यस
Yes, my lord, will, if my lord doesn't see any of the other paragraphs of this judgment except 69, we have referred to this aspect only to clarify the position that it is beyond any trace of doubt that civil action for which there is no codified law in India, a common law right can be taken recourse to under section 9 of the Civil Procedure Code unless there is a specific statutory bar in that regard. So it remains. Then, my lord, then it goes on to the discussion about the criminal law. And if my lord comes to page 205, 151, paragraph 151, that's the ultimate finding. Therefore, in the ultimate conclusion, we come to hold that applying the doctrine of balancing of fundamental rights, existence of defamation as a criminal offense is not beyond the boundary of Article 19(2) of the Constitution, especially when the word defamation has been used in the Constitution. So that is the final answer. Only one point, my lord, if my lord comes to page 228, paragraph 209. Another argument was made, but this is relevant to the discussion we were having. We will be 209. We will be failing in our duty if we do not take note of the submissions of Mr. Bhambani, senior counsel. It is submitted by senior counsel that the exceptions to section 499 are required to be considered at the time of summoning of the accused. But as the same is not conceived in the provision, it is unconstitutional. It is settled law that those who plead exception must prove it. Just this one line I wanted to. So the onus was on them. It is settled law that those who plead the exception must prove it. Of course, here the counsel was trying to argue that before issuing the summons, you should decide whether you come and. But then it was held, no, the summons will go, they'll have to come and prove themselves. But this line is very important. So this shows that the law of the civil law of defamation is very much in existence and there. Now, if my lord comes to the index of my compilation first. So 1954 Supreme Court, the first judgment, I'm not going to, this is quite complicated, so I'm not citing that, but this is recognizes, this recognizes that a order passed by a authority from another jurisdiction does not affect the jurisdiction of this. So the question was in that case, if I remember correctly, and I have not cited, it is that 101, the last paragraph. Yes, if my lord only considers paragraph 18 at page 14, after this 2016 decision, I really don't need to go into these. But here it was whether the Government of India Act 1935 had conferred a right on the princely state of Rajasthan. So after it became a state under our country, under India, whether they claimed an exemption to pay tax. So it was held that no, though the law in force comes, then it can't be contrary to the constitution. So the constitution has to avail. But this is this was the first case we found, so we have put it in, Manoj, but I think your lordship can ignore it. We don't have to go into the whole thing. So it is just, the facts are very complicated, Manoj. Para 6 and 18, your lordship will note, but I don't think my lord will have to trouble yourself with that. Then the second decision of mine, AIR 2002 Guwahati. Well, I'll come back to that. That is the decision I'm relying on for the basic principle of defamation and damages. I've placed it before. I'll come back to it, my lord. I'm on this point of this common law.
You have to satisfy this code. How the compensation?
Yes, I have those. So one of those cases is this Guwahati case, and I'll show. Now, if my lord,
with regard to the publication, not publication, that aired and all these things,
Hmm.
that is not disputed.
No.
They have taken, it is a correct. It is a correct as per their evidence, they have not proved. They
Yes.
have not adduced any evidence. So now only the question is that how the compensation, how this court can, so
I will show my the principles that must be considered, but unfortunately, I have to say this, that ultimately it depends on my law.
No, that is
It's
different thing.
completely a discretionary relief.
No, with regard to that,
Yes,
but
the quantum
Ah.
is completely discretionary because no special damages are allowed are required to be proved. No loss is required to be proved. I'll show those. I'm only I'm saying unfortunately because I can only assist your lordship with the principles.
Okay.
The once the liability is found, then the quantum is in connection with how malicious was it required, what is the reputation of the company, etc. And one other important thing that we will really be pressing is it's a big company, that won't make a difference how much money we get. It's the principle of the thing, but the costs we shall be asking for. The costs of the litigation, because it's dragged on for so many years, this litigation. So costs we will definitely be asking for, but as far as compensation, I'll show the principles, of course, but it will depend on whatever my lord decides. Now I'll take my lord through these cases. I want to finish it off today. The case number 3, this 1960 case and the 1965 case, these concerned, the state of West Bengal was running a market. At that time, the Corporation of Calcutta issued them a notice and said that, no, you have to get a license. You can't run a market. So they took the defense that we are the state, we are beyond the statute. So we don't have to pay the license. Then this case, 1960, 1355, this was followed in 1965. So ultimately, there were dissenting judgments, but I think the judgment came that they didn't have to pay. Now, these were again reconsidered by a 9-judge bench, which is the 1967 case. I should have just only shown that because that covers these legal points about the law in force, etc. is discussed. So this is just history, but I'll just show quickly if my lord comes to page 51 first. This is the fourth case, because it sums up the earlier case. This is the case in dispute was the 1960 case. Then in 1965, it was followed, page 51.
Yes.
51, yes. From page 51, paragraph 17, if my lord sees first. 17 and 20, I will be citing. 17 and 20. So just from the top.
Yes.
In the second line, in other words, is the doctrine of common law, which was introduced in this country and followed, law in force within the meaning of Article 372. If it is, then by virtue of Article 372(1) itself, the same law would continue to be in force until its validity is altered, repealed, or amended. So, till it is changed, it is the law of the land. This question can no longer be in doubt because of the decision in the Director of Rationing. This is the 1960 decision, my lord. I've given the case.
Yes.
In that case, the court was called upon to consider the question as to whether the decision of the Privy Council in such and such, which had laid down a certain rule of interpretation, could be said to be the law in force within the meaning of Article 372. The majority judgment indicates that the rule of interpretation of statutes enunciated by the Privy Council amounted to a law in force, and as such, it continued to be in force even after the Constitution was adopted, with the result that according to the majority opinion, the rule of interpretation of the statute, that the state is not bound by a statute unless it is so provided in express terms or implication, is still good law. Then, Mana 20. My lord, of course, in 19, Justice Wanchu took a different opinion. There was a dissenting opinion. 67 will sort this out eventually. Paragraph 20. It is, however, clear that there was no difference in opinion as to the question that common law was included within the expression law in force. So tort is a common law, it was a law in force. The majority judgment expressly states that the relevant expression law in force includes not only statutory law, but also custom or usage having force in law, and as such must be interpreted as including the common law of England, which was adopted as the law of this country before the constitution came into force. Justice Wanchu also agreed to this view because he expressly observed that the royal prerogative, which deals with the substantive rights of the crown, etc., and the priority of the debts, well, here they had gone into whether the king in England had to pay taxes or not. So then at the end of that paragraph, the last part of paragraph 20, therefore, this decision clearly shows that the rules of common law relating to substantive rights, which had been adopted in the country, enforced by judicial decisions, amounted to law in force within the meaning of this. Then, now if I take my law straight to the 1967, and that is at page 230. 230 after Subramaniam's, yes. Here it's a bit clearer because I was also quite shocked that the government wouldn't have to pay.
Yes.
Now 230, my lord, if it starts 1967, Supreme Court 997.
Yes.
This full bench of 9 judges has been constituted to consider the correctness of the decision in Director of Rationing versus Corporation of Calcutta. This is that 1960, where, so that is one, yes, at paragraphs 3 and 4, my lord. Now, the facts are given in paragraph 2. It's what I told my lord. The state of West Bengal was running a market without a license. Then paragraph 3. Learned Advocate General of the state of West Bengal raised before us the following point. The state is not bound by the provisions of the statute unless it is expressly named. The principle equally applies to a sovereign and non-sovereign activities of the state. And Mr. Bindra, appearing for the Attorney General, raised before us the third point, that the court has no power to review its earlier judgment. That was held that this no longer res integra. The Supreme Court can review its own judgment. In any event, this was a 9-judge bench considering. So the extra point is not necessary. Then 4. While the Advocate General contended that the rule of construction in favor of the state was a part of the common law of England, accepted as the law of this country, and therefore was the law in force within the meaning of Article 372, Bindra argued that the said rule of construction was law of the land, and that it was declared so by the Judicial Committee in the province of Bombay's case. This is an earlier case, and therefore was law in force. Then the third point is not important. Now, if my lord comes to the last part of this, yes, paragraph 22, my lord, at page 241.
Yes.
It's really repeating the same thing, my lord. Let us proceed on the assumption that it has been accepted as a rule of construction throughout India. That this leads to the question whether the rule of construction is the law of the land after the constitution came into force. Under Article 372, all the laws in force in the territory of India immediately before the commencement of the constitution shall continue in force therein until altered, repealed, or amended by a competent legislator and other competent authority. Can it be said that the canon of construction was the law in force which can only be amended by the legislator? The explanation 1 to the said article, the expression law in force shall include a law passed or made by the legislator or competent authority in the territory of India before the commencement of the constitution. It was held by this court that the said expression includes not only enactments of the Indian legislature, so all our basic acts are pre-constitution, and also the common law of the land, which was administered by the courts in India. But it is not possible to hold that a mere construction adopted by English courts and also by some Indian courts to ascertain the intention of Parliament of legislature was a law in force within the meaning of the term. There's an essential distinction between a law and a canon of construction. The distinction between the law and canon of construction has been noticed by us earlier, and we have held that the canon of construction is not a rule of law. We are not concerned here with the statutory rules of interpretation, and therefore of the opinion that the rule of construction is not the law. So how we then the next question is whether this court should adopt the rule of construction accepted by the Privy Council. And there are many reasons why the rule of construction is inconsistent and incongruous in the present setup. We have no crown. The archaic rule based on the prerogative and perfection of the crown has no relevance in a democratic republic. It is inconsistent with the rule based on the doctrine of equality. So that went and the government was held liable. So this is the important part, paragraph 23. And then 24, there is therefore no justification for this court to accept the English canon of construction, for which it brings about diverse results and conflicting decisions. On the other hand, the normal construction that the General Act applies to citizens as well as to the state, unless it is expressly or necessarily or by necessary implication, exempts the state from its operation, steers clear of all the said anomalies. In the prima facie, it applies to all states and subjects alike, a construction consistent with the philosophy of equality enshrined in our constitution. This natural approach avoids the archaic rule and moves with modern trends. This will not cause any hardship to the state. The state can make an act if it chooses for the exemption. So, then it goes into the fact, the important thing is they recognize the law. Here they made a distinction by saying that the Privy Council decision that was cited was a matter of construction. It was an aid to construction, it was not really a law, because that time they were referring to the Crown, which has very different powers from us. Then paragraph 26, that's the answer. For the aforesaid reasons, we hold the state is not exempt from the operation of section. Because we had put in all these earlier judgments, it took a lot of time to discuss. I was quite shocked for that first judgment that the state was exempt with the prerogative. So one of these are the decisions in respect of that law in force that goes. Now, if my lord comes, there's only this decision of 1936 Bombay 114, that's page 272. This decision and the Guwahati decision I'm relying on in full, because they are simply defamation cases and the principles of defamation and damages are given. It's page 272. I think it's in volume 2. Volume 2?
Yes.
Yeah. So here, my lord will note, read paragraph 1 just to tell my lord what the facts were, and then paragraph 7 and a few other paragraphs. So this was a liable action. Plaintiff was a private limited company and it was doing Provident insurance business. So the defendants, if my lord comes to the last 4 lines of this first paragraph, they passed a resolution which is referred to as the boycott resolution, recommending that certain free insurance companies, including the plaintiff, should be boycotted by the public. So this was the issue, and it was published in a newspaper. So now if my lord comes to paragraph 7, it's at page 275 of the compilation.
Yes.
This is again to do with the company can sue for defamation. The plaintiff's cause of action is based on the report published by the defendant committee on the boycott resolution and the heading of the publication in the issue of the Gujarati, and that's the newspaper. And it is alleged in paragraph 13 of the plaint that by reason of these libels, which the plaintiff company complains of, it has been injured in its credit and reputation and in the way of its business, and has suffered a great loss and damage. The plaintiff company claims rupees 50,000 in lump sum, this is in 1936, as general damages, which means such damage as the law presumes to be necessary, to be a necessary consequence of the defamation, and is distinguished from special damage, or to put it more accurately, actual damage, which is not presumed, but it has to be alleged and proved. It has been held that in the case of a company or trading corporation, the words complained of are not actionable without proof of special damage, if they refer only to the personal character and reputation of its officers. So if it says that about its officers, the human beings, but words calculated to reflect upon a corporation in the way of its property or trade or business, and which are calculated to injure it therein, may be actionable without proof of special damage. It was pointed out by Lord Esher in 1894 that it was impossible to lay down an exhaustive rule as to what would be liable of a firm or company, but it has been generally held that a corporation has a trading character which may be destroyed by libel. For instance, it was held in that case that it was defamatory to say that a colliery company that the cottages let by its proprietors to its colliers and workmen were in insanitary condition. This is the mother case which says this Seton, I think, South Hetton coalfields. For such imputation was likely to injure the reputation of the company by way of its business. If it is alleged that a trading company is insolvent or will be insolvent in the future, or consists of alien enemies in its constitution and management at the time of war, it is entitled to sue. It can also sue if it is alleged to be in practice of holding false hope to the public and entering into contracts which is absolutely secure. Then Pollock CB suggested that the action of a corporation to sue by libel was limited to the publication which affected its property, but it has now been held there is no such limitation. The question for consideration is whether the words complained of in disparagement of the corporate property or its business or reputation. In the words of Lord Blackburn in 1882 appeal cases, an action will lie if the statement is published without lawful justification or excuse and is calculated to convey to those whom it is published an imputation that the plaintiffs injurious to them in their trade, imputation on the plaintiffs injurious to them in their trade, holding them to hatred and contempt. Then, if my lord comes, yes, paragraph 8 also, the principles are still there. In order to succeed in this action, the plaintiff must establish that the words complained of are defamatory in the way of its business, that they are published by the defendants, and that they refer to the plaintiff company. So these three things. As I have said before, the publication has not been denied, even in our case. The allegation, however, is that the words were falsely and maliciously published, and this was denied by the defendant. So they tried to take the defense of fair comment. The word falsely and maliciously appear invariably in the pleadings in a defamation case. All defamatory words are presumed to be false, and it is for the defendant to prove that they are true. So this is the important one. This is the principle why we are relying on this case. Now, malice can give additional damages. That's a different thing. But malice, in the sense of a corrupt or wrong motive, is not essential ingredient of the cause of action. It is not the gist of the action. The liability for defamation arises not from the malicious intention to defame, but from the publication of the defamatory words. It is therefore for the plaintiff to prove malice, except when the defendant pleads and proves privilege, or fair and bona fide comment on the matter of public interest. Malice may also be a material in the assessment of damages. The words complained of may be defamatory in their ordinary sense and must be prima facie understood by the court in the same sense as the rest of mankind would ordinarily understand them. They may also be defamatory in the secondary sense, in which case the plaintiffs have to allege and prove what is called innuendo. That is, the plaintiff must show that the words, not defamatory in their ordinary meaning or special application, are used in specified libelous meanings. The burden is on the plaintiff to show the meaning that they have assigned to the words. Well, I have had innuendo and words, and we have tried to give the explanation of what we understood it to be. It's there first in the plaint, which is not specifically denied in the written statement, and my witness has also said. And from the bar, we have given cases and dictionary meanings of these words. So what we think it will mean. Now, before I finish submitting these cases, another point which is important, my lord, to bear in mind is that they are taking an inconsistent and self-destructive stand, because in their notes of arguments, they have taken the stand, you have not proved the CDs, we have not, you have to prove that. So that is inconsistent by saying, yes, I've said those and this is justified. So the justification and that cannot stand, my lord, together. That I'll show another decision on that. So there, which I think it was in this decision itself. Anyway. So they can't take both the stands. And here it says that I don't have to prove damages, but if for malice, I want additional damages, in particular, those I have to prove. In fact, I tried to show that my transmission and distribution loss had become much more during that period. But to be fair, my lord, we didn't have the evidence for that. We just given a chart to that extent. Now, as far as damages are concerned, this decision is also, there are some important parts. So my paragraph 7 and 8 I've already indicated to my lord. Now, if my lord takes 13. 13. No, I'm sorry, 15, my lord, page 280, 15.
Yes.
It was argued on behalf of the defendants that the words complained of in this passage are really not defamatory of the plaintiff, but only a fair and bona fide comment on a matter of public interest. If the words are such comments, they are not actionable. Plaintiff's counsel argued that the defendant cannot put forward an alternative plea of fair and bona fide comment after first pleading that the words were not published of or concerning the plaintiff company. For the defense of the fair and bona fide comment, in effect, admits that the words were published and concerning the plaintiff company. In my opinion, however, it is open to the defendant to raise alternative plea, for all kinds of inconsistent pleas can generally be taken by the defendant. They cannot plead the defense of fair and bona fide comment only and then seek to show that the words were not published of or concerning that of the plaintiff company. It was pointed out in 15 Bombay Law Reporter that it is the essence of the plea of fair and bona fide comment. So they admit the fact, otherwise they wouldn't say it's fair and bona fide comment. Then paragraph 17, this thing I was telling my lord, that there's a difference between opinion and a fact. The defense is only applicable, fair and bona fide comment defense, is only applicable to expressions of opinion as distinct from assertions of fact. In the pleadings, though again it's the language, they have said it's a fact, what we are saying. So they are not saying it is their opinion. So this defense goes. This defense is only for opinion. The onus is on the defendant to show that the matter commented upon is a matter of public interest, that the statements of fact relating thereto are true, and the comments based on the facts are fair and bona fide. So again, it's repeated here, the assertion, he who asserts, he has to prove. And then the other discussion is there. Finally, in this judgment, my lord, the last few paragraphs. If my lord comes to paragraph 31, no, 33, page 286. The only question that remains is one of damages. The plaintiff alleges in paragraph 13 that it was greatly injured in its credit and reputation and way of its business, and it has been brought to public scandal, hatred, etc. And that its business has fallen off and it has become difficult and impossible to enroll new members, and that some of the directors have resigned. The onus of proving damages is on the plaintiff. It appears that 2 original directors resigned. Then one of the facts are discussed. If my lord comes then to paragraph 36.
Yes.
Well, just before paragraph 36, last line of 35, after all that discussion, there must have been some fall in business, but as to how much it was, is only verdict can be not proven. So they will have only general damages. Or if I may read 3 lines above that one, they have, however, lumped it up with a claim for general damages by alleging a fall in their business. There is no sufficient evidence to show what the fall was before the date of filing of the suit. The evidence of as to the subsequent fall in business is also not satisfactory. There must have been some fall, but how much it is as the only verdict is not proven. The plaintiff company must therefore fall back upon its claim for general damages. So it is not always easy to assess general damage according to any legal standard of measurement. Damages are a discretion of the juries in England and of judges in India. Imputations in the way of business of a trading company or corporation or company are generally considered to be a serious matter, but all the facts and circumstances connected with the corporation and company have to be scrutinized. About the defendants bona fide, I have no doubt. As pointed out by Lord Esher, a man may use excessive language and yet have no malice in his mind. And to use the words of Lord Dundin, in considering the evidence of express malice, no nice scales should be used. So it's not a very, as far as malice was concerned, he couldn't prove it. The plaintiff's witness admitted that the defendants were respectable persons and there was no animosity towards the plaintiff company. This is not in our case, though. A suggestion was made that the defendants did not want small insurance companies to flourish, as they or the near relations were interested in bigger insurance company. That is an allegation that has not been proved. There is no seriously aggravating circumstances against the defendant, etc., my lord. Now, if my lord comes to the last part, moreover, at common law, the fact that the defendant has apologized to the plaintiff is no defense. It is clear that the plaintiff company
and no grudge.
Now, that it is clear that the defendants have no grudge against the plaintiff company or anyone connected with the plaintiff, nor can it be said that any of them had or any of had any R of his own to grind. It should be own axe or something, his axe to grind. Under the circumstances, it will be fair and reasonable amount of compensation if I order the defendants to pay the company so much, 1,000 rupees, and I order them to pay the plaintiff's costs, etc. So general damages was given as they felt. This was in 1936. So 1,000 rupees was still a substantial sum. Now, maybe I'll take 10 more minutes, but I want to show, my lord, the judgment that is not in my note, the last one, the page 550. Those English cases and Gatley I will also show. The last one, this is the latest I could find by our court. But again, it just goes to discretion. If my lord comes to page 550, a short decision. So here the defendant had described the goods of the plaintiff as a spurious manufacturer, had called the plaintiff. This is at page 551. Your Lordship, you will see the words have been used, spurious manufacturer.
Yes.
So now if my Lord comes to page 553. On behalf of the plaintiff, it is contended that the words spurious manufacturer are defamatory as on their own, as well as when read in the context of the email of 9th July. The words are libelous in the way of the business of the plaintiffs. Since such words are per se libelous, the plaintiffs are entitled to general damages. The plaintiff, not having pleaded or proved special damages, are not claiming the same. Then reliance was placed, my lord, on these decisions. This South Hetton Coal Company decision that's there, my lord.
Yes.
I've just referred to it in the other matter. This is that case where the colliery company had not provided proper quarters for its employees. And it was insanitary. They said that. So they said that is also but in its business. It is contended that when defamation is with regard to the way of a business of a company, such company is entitled to damages. Then on general damages, reliance was placed on, well, several decisions are there, including 36 Bombay, which I just cited.
Yes.
And Rajasthan, I think I had cited before. Be that as it may, the decisions are cited. Relying on these authorities, it is contended that the court should grant general damages in favor of the plaintiff at the rate deemed appropriate. So it was left to the court. And then the defenses of justification is discussed. Then if my lord comes to page 558. 558. Although justification is a defense in the action for defamation, in the facts of this case, the defendant has not substantiated such defense by any evidence. Here also no evidence. The defendant has not led any evidence. The evidence on record does not support such a defense of the defendant. The absence of DNV, that's another party, has neither hindered nor embarrassed the trial. The defendant has not even applied for adding DNV as a party. The defendant has not substantiated that DNV is a proper, necessary and proper party. The first issue, therefore, is answered in the affirmative. The word spurious is per se defamatory. This is only one word. Well, there's so many in our case. In the facts of the case, and the plaint, as it stands, does not disclose a cause of action. Then here, the second issue is connected together. This is about the damages. It is now well settled that the following cases, slander is actionable per se without proof of special damages. It comes to D, an imputation against plaintiff in the way of his business. Then in Piyush Kanti Datta's case, my lord, it has been held that the task of the court is to award fair and reasonable compensation. Your lordship has not met Mr. Dutt was a very senior member of our bar library. And I think Justice Ajit Sengupta passed this order. I haven't seen it. 1 rupee was given. He was very upset with the whole. He was held that it was defamed everything. But only 1 rupee was given because he said you don't need the thing. Then, my lord, finally, yes, page 560, my lord. A defendant is liable if a defendant is actually aware that what the defendant says or does is likely to be reported, and that if a defendant slanders someone, then the slander is likely to be reported in whole or part. In the present case, the defendant has issued an email certifying such an agency. Well, those are the facts of the case. And then the last paragraph, it says defense is no, apology is no defense. Even if they had apologized, it's not enough. It goes on to find that the defendants did not have any grudge against the plaintiff. The court, however, still has granted compensation on fair and reasonable assessment. Then in the other case, Balaram also, fair and reasonable compensation was given. In The next case, it has been held where there is injury to the reputation of a person, substantial damages ought to be granted as general damages. The authorities cited are of the view damages are presumed in cases involving injury to reputation. In such cases, the court is entitled to award substantial damages, although proof of damage is not produced. What would constitute proper damages is a matter of impression. The quantum of damages requires consideration. In answer to questions such and such of the witness has stated that the plaintiffs are loss-making companies. The plaintiffs have not led any evidence as to the quantum of damages suffered. The plaintiffs contend they are not claiming special damages, and once defamation is established, they are entitled to general damages. Similarly, in my case, my lord, the plaintiffs contend that the quantum of general damages need not be established. The plaintiffs have been defamed as to the way of their business. They are therefore entitled to general damages. The hostilities between the parties have a history. Quantum has to be considered in the context of the history of hostilities. Then these are theirs. And therefore, a compensation of 50,000 euros was given by justice, since it was a German company. And the plaintiff will be entitled to a decree of a rupee equivalent of 50,000 euros at the exchange rate prevailing at the date of judgment. Will be paid. And costs were given for 1 lakh. So it is ultimately, like I said, I can only assist my lord to the fact that it is left to your lordship, considering, and ideally, my lord, I would request my lord once to have a look at the video once before. I don't know if the pen drive was given, because later we've again converted into a pen drive. Of course, my learned friend is not there to object. Now the seat from the CD to the pen drive, it's gone. But my lord will give me another 15-20 minutes. The other English cases that are there. It's only to do. Your lordship will recall from my note. I'll just tell my lord. The last few pages, the page 50 onwards, I have quoted Gatley. We had also handed over the it long time. No, ring binding. I've got a copy. It's the quotation is in italics. That is the entire thing. On page 50, my lord will take it that up to. So these cases have come up because they were in Gatley. So, but the textbook has so many cases. Your lordship will see. The trading corporations. This entire quote is there. So all the cases that were there in the footnotes, those we have included in our notes.
Yes.
But the principle is this. I can show that they're very long cases. I'll take 10 minutes. I'll try to show those, but I'll be very quick, my lord.
Okay.
And all it says is this. A company, a trading corporation has a trading character, and defamation may ruin it. The reputation of a corporate body is capable of being and will usually be not simply something which the directors take pride, but a positive asset. Accordingly, it may maintain an action in libel or slander for any words which has the tendency to damage it by its way of its business. And it is not necessary to prove special damage. So this principle with these cases, that's all I have left to do.
Okay.
Next table.
Suffering for the suffering for the defendant. Counsel for the plaintiff has argued at length, but due to paucity of time, hearing could not be completed. Fix cover date hai koi?
Well, if it can be next week.
No, my lord, please grant 2 weeks time to go through all the judgments.
What?
2 week time.
You will argue?
No, my
Yep.
lord. I have instructed to.
I'm giving the
ask for-
reply to his.
Letting
As far as my cases are concerned, it's dealt with.
10th April 3:45. Come on that day, please.
3:45.
Item number Karnani Propert. Witness.
Yeah, for the defendant, my lord. Today's our witness, my lord.
I appear for the plaintiff.
Defendant's witness.
Yes.
Yes.
Yes. Inform one.
Repeat after me, sir. I solemnly affirm
I solemnly affirm
that whatever I depose
that whatever I depose
by way of evidence,
by way of evidence,
I shall speak the truth.
I shall speak the truth.
No part of it shall be false,
No part of it shall be false,
and I shall not conceal anything.
and I shall not conceal anything.
What is your name?
Prem Gyani.
Spelling?
PREM
REM.
GIANI. GIANI.
Father's name?
Late Hashmat Rai Gyani.
Late?
Hashmat Rai Gyani.
Spelling?
HASH MATRAI.
Your age?
57.
57. Occupation?
Business.
Business. Residential address?
Empire Building, 16A Guru Sadar Road.
16 for the road.
Kolkata, I think it's 71.
Yes.
Yes.
Mr. Gyani,
Yes.
can you tell me what is your relation with the defendant?
I'm the director of the defendant, Calcutta Carpets Private Limited, an incorporated company. Sorry. An incorporated company.
Are you aware of the fact that the suit has been filed against the defendant company?
Yes.
Have you gone through the plaint?
Yes, I've gone through the plaint.
In this case, a written statement has also been filed. I am handing over you the copy of the written statement. Please look into this. Affidavit portion. Please go through the affidavit portion.
Tell the page number.
Page 11 of the plaint. Plaint. Written
11.
statement. Written.
Madam, this
Can you tell me who has signed this?
This has been signed. Okay.
Can you tell me who has been signed this written statement? Who has affirmed this written statement?
Chirag Tekchandani. Mr. Chirag Tekchandani.
Do you know who is Chirag Tekchandani?
Yes. He has been appointed by the defendant to sign affidavits and pleadings through a board of resolution.
Is there any signature appearing in the?
Yes, I've seen the signature and I know the signature of the same person.
Mr. Gyani, have you gone through this document?
Yes, I've gone through the document. There is one error, I think. where Mr. Ramchand's name is written by mistake instead of Gopal Das.
Ramchand's name has been wrongly.
Which page, which paragraph?
It's on the page number.
This one, sir. I think it's paragraph 5.
Paragraph 5, page number 3.
Paragraph 6 and 7 of the, it's point number 5, sorry. Page number 3.
Point number 5.
Oh, sorry, one. This is a mistake in that.
Yes, next. Huh? Achha, non.
There's a mistake in that. One particular point, maybe.
May I ask another question, my lord?
Huh?
No, I'm not able to find that.
May I ask another question, my lord?
What will happen to this question?
That will lead to this.
You will drop. He has to give the answer.
Not able to locate that. One point, I'm not able to locate that.
I'm not able to look at that.
Yes, next.
Mr. Gyani?
Yeah.
Have you, you said you have gone through the written statement.
Yes.
Are the contents of the written statements are true and correct?
Yes, absolutely correct. Yes.
Please come to page 2, paragraph 4 of the written statement.
Yes.
I'm reading this for you. With reference to the paragraph number 2 to 5 of the plaint, it is stated that Hasmat Rai and Ramchand were partners of the partnership firm, Calcutta Carpet Store, until the time of the death of Ramchand. After Ramchand had died, his son Gopal Das had become a partner of the firm. Hasmat Rai and Gopal Das continued as partners of the firm Calcutta Carpet Store, which was a tenant in respect of the suit property. The firm Calcutta Carpet Stores continue as a tenant in respect of the said premises until the death of Ramchand in 1980. This, according to you, is the correct statement.
No, Ramchand, this is the error.
Absolutely leading, my lord.
this is, I don't object.
You read
Junior
it,
member
but the
is,
word could-
I'm sorry, madam.
already has given the answer, he could not locate.
locate it, let him come on the next location, but he's still reading.
ना ना ओपन वो नहीं, आपको तो नहीं बोले थे, लिखने की जरूरत नहीं. Yes, next.
So have you gone through the plaint?
Yeah.
So according to you, plaint is correct. The contention of the plaint is correct.
No, the plaint is not correct.
Can you tell the court that whether who was the tenant under the plaintiff?
First, it was Mr. Ramchand and Mr. Ashmat Rai. Initially, they were both tenants under the plaintiff. And after this, after the death of Ramchand, his heir, Mr. Gopal Das, came in, and he became a partner to the firm of Calcutta Carpet Store. So then the firm became the tenant of the plaintiff. A letter was given on the company's letterhead to the plaintiff to issue the tenancy in the name of Calcutta Carpet Stores.
I am showing you Exhibit D of the plaintiff. Can you tell me what is the document about?
This is a letter that has been issued by the firm to the plaintiff to incorporate Gopal Das, who is the heir of Ramchand, and make the Calcutta Carpet Store as a tenant.
Now I am showing you another document, that is Exhibit E. Please go through the document. And tell the Honorable Court what is the document about.
This is a document which is given by the company, the Calcutta Carpet Store, to the plaintiff that Gopal Das is the new partner of the store, and the legal heir of Ramchand, his widowed wife Lakshmi Bai, has given the consent in the same. They have no objection to the same. And the rent receipt should be issued in the name of Calcutta Carpets of the firm.
Can you tell me, can you tell me who was this Gopal Das?
Gopal Das was the son of Ramchand.
And is he alive till then?
No. Ramchand died in the 80s, sometime in the 80s.
I am questioning about you, the Gopal Das. Are you aware when he expired?
No, I don't know. Around the late 80s, but there has been no claim by any of his heirs who have ever come till today or asked for anything. Yeah, of Gopal Das ever. Or have they ever come?
Or they have come.
Are you aware of the fact that after the death of Gopal Das, what happened to Calcutta carpet stores?
After the death of Gopal Das, the firm automatically stopped functioning as per law, and because my father was not even very, his health wasn't permitting, so he had stopped the work totally, and the premises was handed over to the plaintiff. In around, can I continue? In around 90s, my brother, Mr. Suresh Gyani, wanted to start a business, and Suresh Gyani, he wanted to start a business, so he found that this premises was available, and he took possession of the premises along with me, and we started a business there.
Have you taken a permission of anyone when you were entering in the?
No, there was no permission taken by anyone. Sorry.
No permission was taken by you.
Have you intimated the plaintiff that you have taken the possession?
No permission was taken. There was no questions from anybody after we took over the possession. There was no questions by anybody, or no one asked. And we were running the business. Uninterrupted, continuously. And hostile to the open world.
Mr. Gyani, when you have entered in the suit premises, did the plaintiff object you?
No, there was no objection. There was no objection by anyone.
Yes, next.
What happened after you have entered the suit premises?
We started running, we had renovated the premises, which was probably closed for a long time. And after renovation, we started running the business. And we started running a carpet business, which was new to the store, basically. So the new store, we started running a new carpet business.
Yes.
After you started this business, did you take permissions from the authorities?
No, there's been no permission ever taken from anybody. From the plaintiff side, no one. We had taken permission, and we got trade licenses done for the firm. And we started the business.
When you started the business, did you obtain trade license?
Yes.
You already stated.
We had taken.
You have Mr. Gyani, please tell what happened after you have taken the position and started running business in the name of Calcutta Carpet Stores.
We had started running the firm after basically taking our license, and
Is the farm
after we started, I think over a period of a year's time.
For a period of years.
Over a period of years' time.
Yes. Yes, what has happened after years' time?
after years time. Complete as well, what is it? After years time, what happened? No, you have to bullet.
3 years time.
Contract for the company take over.
After a year's time, basically
I couldn't
we
understand.
we changed the
The years time. Yeah, I have this. Somebody whispers, I can't understand.
No, you stated our question is
years time. I understood that now.
What is the
the
answer?
dissolution of the firm took place, and we the firm was dissolved, and it was taken over by a private limited company.
After the years of the business.
After a year's time.
After years' time.
Yeah.
Hmm.
The firm was taken over by a private limited company where we were directors only.
Yes. Next.
I am showing you a document. Well, this is the new document.
3:30. You continue.
No, my lord. I will take.
In English, there is a saying saved by the bell. Another 10 minutes. I am here. Another 10 minutes I could have.
No, but secretary is there. He want to continue. There's no problem.
Active secretary.
That's why.
Person of our choice. And we every day I've disturbed him so much over the last 3 months after he has become. To the last secretary, Mr. Sen, I had issued a formal notice that I am having mental issues because there is a rat who's coming to my table. So please take steps. Formal notice.
For rat.
For rat. The secretary also will think of something.
Oh, he has tortured him enough. He has tortured him enough.
Okay, please system.
Another 10-15 minutes of chief and then we'll not.
Why did you have there?
Sensation suffering for the plaintiff. Sensation suffering for the defendant. Defendant witness is present. Examination in chief started, but due to paucity of time, examination in chief could not be completed. Accordingly, chief is deferred. कब है डेट कुछ है? Friday क्या मिले? Let the matter appear on 11th April at 3 p.m. 11 3 p.m.
Lordship. Lord, if he, I'm sure, my lord, this examination will be concluded by 4. I'll start my submissions from 4. My witness in the box. I'll be prepared.
Cross examination?
No, that will be over by 4.
My lord,
I will take it.
My lord, may I mention a matter for extension? My lord, it's expiring today.
Which matter?
ODC 27, Mr. Subhashish Sengupta is appearing for the respondent at Pulak Modi.
Respondent.
It's expiring today, my lord.
You are appearing for?
I for the respondent, your lordship.
Yes.
Some of the respondents. I have also filed an application for your lordship for interim order. Your lordship can extend the interim order, but your lordship kindly fix a date, your lordship, so that My application I can move.
So and so appearing for the plaintiff,
Lordship.
so and so appearing for the defendant.
Your Lordship, as per your Lordship direction, the affidavit in reply of the same can be taken on record. We have already served them, Your Lordship.
Which matter? This
matter
matter.
only, Your
Counsel for the plaintiff has filed affidavit in reply.
G.
Have you served the copy?
Yes, Your Lordship.
After serving the copy to the learned counsel for the defendant, let the same be kept with the record. Counsel for the plaintiff submit that the interim order granted and is going to and prayed for extension of interim order. In view of the submission made by the counsel for the plaintiff, the interim order is extended till 2nd May 2024 or until further order, whichever is earlier.
My lord, may it appear, my lord, next week, my lord, any day apart from 7th, my lord.
One thing, Your Lordship, this
Because now there is an appeal court direction. Appeal court has clarified that Lordship can proceed with the interlocutory application during pendency of the appeal.
Your Lordship,
Lordship has not been interfered with.
I could not understand, but the Your Lordship, the bench has changed. Now the matter has come before Your Lordship Justice, before the presided over by Honorable Justice Banerjee. Now he is not here till 16th. Any day, Your Lordship, at least after 16th, so that we can move the
My lord, 21st, Lordship keeps it on 21st, we'll take our chance, my lord.
21st of?
My lord, April, my lord, since he says after any day after 16th, so kindly keeps it on 21st.
No, because the this the original site or commercial?
Commercial, my lord, commercial. Lordship will have no problem.
22nd.
22nd.
22nd April.
But there is, my lord, an observation of the appeal court that this can be heard now.
Item number, this item number?
27. ODC 27.
27. OCD.
Very grateful, my lord.
Yes.
Item number 6, my lord.
Yes.
Volume 6. My lord, if your lordship kindly, I'll be very brief. My lord, this was the order passed by your lordship at volume 6, page 785. The order starts at page 785, volume 6.
Volume 6 in the contempt application.
My lord, the plain petition, they have annexed, the juniors have annexed it.
Page
785, the order starts.
Yes.
My lord, the penultimate paragraph, which is at page 791, paragraph 23.
Men agents,
respondents, their men's agents.
section alienation dealing with the transferring and disposal of property. Yes.
My lord, now if your lordship kindly takes page 795, this is proof of, this is the dispatch.
Yes.
Postal receipt, my lord. The third one, it is the private developer.
798. 798.
795, if your lordship kindly takes the third one, your lordship will see the numbers are 7205.
Yes.
And my lord, the proof of delivery on them is at page 798. It was delivered to them on 22nd of March 2025.
22nd March. Yes.
Yes. Now, my lord, the acts of contempt. My lord, kindly takes page 806. These are, my lord, some drones which are used to take real-time photographs because they will not allow us to go in.
Timestamp.
Page 806. My lord, will kindly see at the bottom 26th of March 2025.
806.
806.
Yes.
This is what is going on.
One by one. Circus Avenue, Ealing, Calcutta, West Bengal. Construction is going on.
Yes, yes. Despite the order. Now, my lord, also the order of injunction also applies that they cannot alienate transfer. That your lordship comes to page 809. Lord, at the extreme left-hand corner top.
Yes.
But it's in American Act, the date, my lord, very small letters, my lord. It is 26th of March 2025.
Yes.
And they are still soliciting, it says price on request.
Yes.
The lordship will see this is the subject premises. 224 AJC Post Road. My lord, your lordship can appoint any junior member of the bar. My lord, I have a judgment also, a full bench of Madras High Court
relying on card, but I do not wish to trouble your lordship. But your lordship may appoint a special officer who can go and just My lord, I will beseech your lordship to issue a rule. The contemners, the name of the contemners are given, they are the office bearers. Because it's a company under section 12(5). Company is a juristic entity.
Paragraph 38.
And I have pleaded in paragraph 38 as to they are the.
Who are the contemners?
My lord, they are the directors.
Pawan Kumar.
Pawan, Anil, Ram Naresh.
Ram Naresh Agarwal. Anil Gupta. Yes.
But the rule.
This is the church property.
Yes.
Yes.
Let a rule be issued.
And also special officer to take symbolic possession.
Your lordship can appoint any junior member of the bar. That would also be beneficial for him, for a member of the bar.
Yes.
My lord, that prayer I have made in prayer F, but I won't ask for a actual physical possession.
Symbolic possession.
It can be in symbolic possession as well.
Issue notice first.
My lord, rule, my lord, because it's clear act of contempt. Clear act of contempt. Despite having notice, despite, these three directors were also served because they are parties. Power of attorneys are in their name. They are parties to the development agreement. They are power of attorney holders. Let a special officer go. I am not asking for any possession. Let him.
So appearing for the plaintiff. A petitioner. The petitioner has filed the present application on the allegation that the alleged contemners have violated the order passed by this court dated
20th March
20 March 2025. By an order dated 20th March 2025, this court has restrained the respondents, their men, agents, servants, and assigns from carrying on any further construction or alienating or dealing with or transferring or disposing of the property to any third party till 23rd of April 2025. The order passed by this court was duly communicated to the alleged contemners, but in spite of receipt of the order, the alleged contemners are continuing with the construction work and also placed the said property and also advertised for sale of the said property on request, price on request. Counsel for the petition submitted, the alleged contemners have violated the order passed by this court, and as such, rule be issued upon the alleged contemners and a special officer be appointed for taking possession of the said premises. Had the learned counsel for the petitioner peruse the order dated 20 March 2025, the photographs showing the construction is going on, and the advertisement made by the alleged contender with regard to sale of the property as per price on request. Considering the above, let notice be issued upon the alleged contender to show cause as to why rule shall not be issued. Full stop. Who is the junior member? But you are busy. You will do. You will do. So and so.
But he has to go tomorrow. But otherwise.
আরে তোর বাড়ির কাছেই বেগবাগান তোর বাড়ির কাছেই
On your route also. क्या बोलता so appointed. Give the name and number. So appointed as special officer to ascertain whether any construction work over the suit property is
Can he go from here, court, my
going
lord?
or not, and whether the alleged contemners have placed the said property, has published any advertisement for sale of the said property. The special officer is directed to immediately, within 24 hours, visit the property and to submit the report before this court within a week thereafter.
Police helping me.
Full stop. It is made clear full stop. It is made clear that in case the special officer require any police assistance at the time of inspection of the premises in terms of this order, and if the special officer made any request to the concerned police officer.
Specify the police station. Koraya police station.
Huh?
ঠিক আছে ঠিক আছে করায়া পুলিশ স্টেশন
Koraya concerned police station or the jurisdiction police station, namely Karaya police station, the officer in charge of the said police station shall provide necessary police assistance to the special officer for inspection of the property in question by the special officer, and so as to enable the special officer to prepare the report in terms of this order. Let the matter appear full stop, and the alleged contempt and let the report be filed on. Till which date you will be available here? By 9th you will file the report. By 9th of April 2025. The alleged contemners also directed to file their so-cause by 9th of April 2025. Full stop. The petition is directed to immediately issue the notice about the alleged contemner by speed post.
Lord, I'm saying, Lord, the order, Lord, will not be uploaded. So, Lord, can I act on the basis of?
Yes, and the remuneration of the special officer is fixed rupees 30,000 for the initial stage. Full stop. The special officer is the advocate on record of the petitioner is liberty to communicate this order to the special officer as well as the concerned police officer for compliance. Acha, 11th April, not 9, 11th April.
Gist of this order. Otherwise, Lord, I was saying, Lord,
with my lord, I have seen that day the orders are uploaded.
Very well.
It will be
In
uploaded.
case it is
In
very
case,
well.
that's why I given the gist of the order.
Great.
Item number 1.
Grateful.
जल्दी करके देना.
The book. WhatsApp call.
My lord, I am acting.
Take away the book, my lord.
Yes. कौन अफेयर कर रहा है कोई? Execution of warrant issued against the judgment debtor. None appears on behalf of the petitioner, a plaintiff. Full stop. The Deputy Sheriff of Calcutta has filed the report dated 4/4/2025, wherein it reveals that no police report has been received from the senior superintendent from the police authorities of Patarkar, Patrakar, Nagar Police Station, Patna, Bihar, or from the office of the Senior Superintendent of Police, Patna, Bihar. Considering the report submitted by the Deputy Sheriff of Calcutta, comma, the officer in charge, Patrakar Nagar Police Station, Patna, Bihar, and the Senior Superintendent of Police, Patna, Bihar, are directed to show cause as to why the report has not been submitted in spite of the warrant received from this court against किसका है वो भी तो नहीं दिया warrant received in connection with the above case. Let the said show cause be filed before this court within 2 weeks after receipt of this notice, after receipt of this order. List the matter on, ये commercial है, list the matter on, आज क्या तारीख है, 4 तारीख, list the matter on 23rd of April 2025. Where is the order? Court का order कहाँ है? टेंथ अप्रैल ऑलरेडी डेट है ना इसका, तो 10th अप्रैल डेट है। 10th अरे उन लोग सब उल्टा सीधा रिपोर्ट देते हैं। लेट द मैटर अपीयर ऑन 10th अप्रैल 2020।